on bail. It is directed to release the appellant on bail pending appeal for 50,000 rupees with 2 sureties each for the like amount in ST case number such and such, with such other conditions to be fixed by the Lenient Trial Court.
I agree. Right. Submission item number 1.
Miller taken of upload to machinery
Yes, sir. Tell us what the matter is about.
Sir, Miller machinery is ill.
Ill. Who's your senior, sir?
AR Maji.
All right. If the AR margin counts for the appellate state to be ill. List on 21st August.
Item number 2.
May I please, your lordship? The only grievance of the petitioner is neither the state nor the private opposite parties could file a counter affidavit due to the pandemic, and in the absence of the counter affidavit, the case has been disposed of. That has been mentioned in paragraph 2, and in paragraph 7, at ordering portion, it is contended that no further action can be taken in the matter even till date. In fact, is specifically controverted by the opposite parties. My lord, due to the COVID pandemic, neither the private opposite parties nor the state could file a counter affidavit.
That's all.
I
Never stopped, sir. Nothing stopped during pandemic.
oblige that some
You yourself, I don't know how many cases you have filed during
yes,
pandemic.
yes, my lord.
So
I was not the conducting
That's not an
counsel.
excuse.
There-
Sir. I know. That's not an excuse.
And the order passed by the governing body has been approved by the Director Higher Secondary Education. And the serious allegation of misappropriation are there against the of present opposite party number 4. And notwithstanding that, the final order, your lordship, at relevant portion of the order,
You have not implemented this order yet.
no, he has been reinstated as a lecturer, but now he is claiming that I must remain as principal in charge of the institution, to
That's a
which the
different cause of
director of higher education.
That is a different cause of action, sir. That's a different cause of action. The challenge in the present appeal is to an order dated 8th August 2022, passed by the single judge, allowing writ petition civil 20396 of 2018, filed by the respondent, whereby he had questioned an order dated 10th September 2018, passed by the president of the Utkal Mani Gopabandhu Higher Secondary School, Okunda Kyonjar, where he was working as lecturer in Odia, placing him under suspension pending disciplinary proceedings. Paragraph. The respondent had also challenged the subsequent order dated 13 November 2018 of the Directorate of Higher Education, Odisha, approving the above decision to place the respondent under suspension. Paragraph. The learned single judge this court has heard the submissions of Mr. Counsel for the appellant. Paragraph. The learned single judge has in the impugn order noted that even in the writ petition, which had been pending for almost 4 years, none of the opposite parties, including the present appellant, filed counter affidavit despite repeated opportunities. Paragraph. A perusal of the order sheet in the writ petition reveals that on 13th December 2018, notice was issued, and on 10th January 2019, time had been sought to file counter affidavit. Full stop. There was therefore sufficient time much before the onset of the COVID-19 pandemic for the present appellant to have filed its reply to the writ petition. Full stop. Therefore, the excuse that there was a COVID-19 pandemic and therefore counter affidavit could not be filed is unacceptable. Paragraph. The learned single judge has further noted that despite the respondent having been placed under suspension since 12 September 2018, even the basic steps for completion of the basically for even initiation of the disciplinary proceedings had been taken. Full stop. No explanation was forthcoming for the delay. In the circumstances, the learned single judge has, while quashing the suspension order, directed reinstatement of the respondent. Paragraph. Having heard Mr. Samal, learned counsel for the appellant, the court is not persuaded that any error has been committed by the learned single judge in the facts and circumstances of the case. Full stop. There is, in fact, no valid explanation for neither initiating disciplinary proceedings for over 4 years, nor even filing a reply to the petition for over 3 years. Paragraph. Mr. Samal then submits that although the respondent has been reinstated as lecturer, he is raising a claim to be appointed as principal in charge. Full stop. That is certainly a separate cause of action, which has no bearing as far as the present case is concerned. For the aforementioned reasons, the court finds no reason, no grounds to interfere with the impugned judgment of the learned single judge. The writ appeal is dismissed.
Item number 3.
None appears dismissed. There, you're there. All right.
It's a matter under the OLR Act. If my lord would see, there's a convenience note which we have given. There's a judgment of a coordinate bench. At page 3, that judgment begins. This judgment was relied upon in the writ petition itself, relating to Sambalpur itself, saying that no permission is required under the OLR Act. In that convenience note, page 4, the judgment begins. Now, this was specifically mentioned in the writ petition in paragraph 9 at page 6.
You can note that. Justice Vishwanath. That judgment, Your Lordship, we had challenged that judgment before Your Lordship, and day before yesterday, Your Lordship has passed this order that this will not be treated as a precedent. And Your Lordship must have remembered that judgment, which my learned friend is.
I don't know about the
Yes, day before yesterday. That must not be done. I will provide you this order.
Then let me, can I pray for an adjournment? Because there are several writ petitions pending on this point. So I wish I had the opportunity to address on this point.
All right.
Yes.
Then we'll just adjourn.
And
at the request
we
of
would
Mr.
also like to file a counter in this writ appeal. So far as this matter is concerned, whether section 23 is applicable to Sambalpur town or not, that is 22, I'm sorry, 22, that will file a detailed counter.
In fact, I also wanted them to file, let them, because my lord may clarify, this is all homestead land. So the single judge simply relegated us to a civil court. Let them take instructions vis-a-vis this land, whether it is required or not.
Right.
So before the single judge, no counter was filed. Let them file counter.
Appellates points out that the land in question is homestead land. And a question would still arise whether the Orissa Land Reforms Act is applicable to the lands in question. You say notice, Mr. Bhanti accepts notice on behalf of respondents. And states that since no counter affidavit was filed before the single judge, he would like to file a counter affidavit in the writ appeal, in the present writ appeal. Paragraph, the counter affidavit will be filed within 4 weeks. Rejoined to penny. We filed the next year.
27.
July.
Same order in 4 and 5.
5 also same.
4 and 5.
4, 5. Yes.
Right.
Item number 6.
I'm grateful.
Ma'am. The petitioner was appended as my lord. Kindly see page 29 as demonstrator in chemistry, my lord. Thereafter, on contractual basis,
29.
29 page one. On 12/9/2015, my lord.
Yes.
Thereafter, his term was extended from time to time. All on a sudden, my lord, kindly see page, my lord, 34. His service was not extended on 7/5/2022. Thereafter, he submitted representations before the authority for extension of his service and for with a further period to regularize his service. My lord, kindly see next page 35. Thereafter, when the authorities did not take any action, he approached this honorable court via annexure 38 relevant portion, my lord. Order of the
For how long were you working as demonstrator?
my lord, since 12/9/2015, the honorable court has directed honorable single bench judge has directed to consider my representation. Thereafter, they rejected my representation via annexure, my lord. Page 41, my lord.
Yeah. You've been working through an outsourcing agency.
Clause 3, my lord. The rejection of
But there's no employer-employee relationship with the university. It's through an outsourcing agency that you've come in.
But-
You have come in through an outsourcing agency.
but
There is no relationship of employer-employee with the
but the
university.
service was extended by the university, my lord.
Correct. But you are coming in through, see, the extension is by the university, but you continue. Let's see the extension letter.
My lord, kindly see, my lord, for a moment. Annex page 30, my lord. Sorry. Page 30. Where is Surendra Sai, University of Technology, Burla, my lord.
Correct. Just read that, please.
Column 5, demonstrator.
No.
My name
Read
is,
the top portion, sir.
in response to our letter of intent number such and such, the outsourcing agents Social Security Service, Bhubaneswar has deployed the following personnel in the departments / sections as detailed as stated below, my lord. With it on 16/11/2015 with the remuneration including EPF, ESI, etc. as noted, my lord. What the they are
No. You're not. The problem. You only want to read it truncated in a way.
the concerned head of offices are to submit the absentee statement in the prescribed pro forma to the undersigned on or before 5th of every month for release of the remuneration to the service provider.
So this is the original order. This is the order deploying you.
My lord.
I wanted to see the order extending your services.
From that, since 2015, I am continuing, my lord.
Correct, sir.
Can you see next page 2018, 10/7/2018.
Yes.
Next page, my lord.
Yes.
Bir Surendra Sai, University of Technology, to whomsoever it may come. I am pleased to certify that Mr. Ajay Kumar Shetty, the appellant, has been engaged as a demonstrator in the Department of Chemistry, Bisut, Burla since 14/9/2015. His appointment is on outsource basis from the university. He takes the practical classes of various programs of the university, such
That's
as
all right. So the point is that even here, it is made clear that you are through an outsourcing agency.
but
Everywhere, so even the next letter, he's been working as a demonstrator on outsourcing basis from Om Sarala Security Services Private Limited.
similar
So everywhere it's made absolutely clear that you've come through an agency.
and similar situated persons, they have also been continued till late, my lord.
Correct.
But the honorable single judge has my lord, I am challenging page 44 in the admission stage. Why?
But it's correct only, sir. You have to make out a point, whether it's admission stage or e-stage. You have to make out a point that you're entitled to. And what is your prayer for regularization? Where's the question of regularization?
No, my prayer is to continue, quash that order, my lord. Since
but
my lord, kindly see my prayer, my lord, first.
Sir, against whom can that prayer lie? You have come through an agency, outsourcing agency. Against whom that prayer can lie, you tell us.
But I am continuing under the institution of university, my lord.
Anyway, all right.
They have not allowed me on the ground that my work is not satisfactory, my lord. They have not issued any notice or in regard to my work, my lord, or in regard to my performance. My lord. Since 2015, I am
think
discharging my
it's
duty.
unfortunate, but you're missing the whole point, sir. You're not able to make out a case. You're not making a distinction between the university engaging you directly and you're coming through an outsourced agency. If you're unable to understand that distinction,
My lord,
you cannot put forth your case.
I understand your
Ah,
lordship's point.
You're not able to put forth your case because you're losing the distinction between these two things.
Well, I have been engaged through outside basis, but I am working under the university, my lord. And
As a law person, sir, which is why these clients are coming to you, you should be able to make out the distinction between these two things. If you're unable to make out, how will you succeed? If you argue the case as if there's no difference between university directly engaging you, outsourcing agency engaging you, how will you put forth your case? Same, you're saying natural justice, whether it's through outsourcing agency or university.
My lord, can take an-
Naturally, you can't make up your point. Make your point.
taken up tomorrow, I will satisfy on that.
Counsel for the appellant needs time to further prepare his case. List on. 10th May.
Item number 7.
May I please? Yes, I number 1823 of 2023 is for leave to prepare appeal because the appellant was not made a party to the writ petition, even though the impugned order directing removal of unauthorized construction of the property which belongs to the appellant.
Show us that your construction is authorized, sir. Show us that your construction is authorized.
Page 42.
Hmm.
Under the ODA Act, a proceeding was initiated against the appellant.
Hmm.
Last para.
Hmm.
Further, the joint squad comprising Tahsildar Puri, Executive Officer, Puri Municipality may be formed to inquire whether any government land encroached by the OP, if found any encroachment of government land in addition to gross violation of ODA Act, that is non-conformities with approved plan, the eviction / sealing may be done jointly. So there's a direction for joint measurement, my lords. So against this order, my lords, next page, an appeal is pending before the appellate authority, that is Housing Urban Development. So the writ petition was filed at behest of a third party who is no way connected either with the property or with the matter, my lords. And deliberately, a wrong code number was assigned to the writ petition, which is evident from page 30, annexure 7, code number 120000, that relates to eviction under Public Premises Eviction Act, deliberately to get it listed before the single bench without impeding the appellant. And so in that view of the matter, the order...
No, what happened? The single judge's order was passed on 15th March. What has happened?
Single judge order, my lords. 15th March.
What has happened, sir? Today we are on 11th April.
11. Pursuant to that, on 3rd April, annexure 9, page 48. Pursuant to that order, the municipality has issued a notice for demolition within 7 days. my lords.
Now that 7 days is over.
My lords, my appeal is pending before the appellate authority against the order. But for enforcement that order of the ODA authorities,
Where
this
is your
petition
appeal?
was filed.
Where is your appeal?
Unless the appeal is at annexure 5, page 24. So during pendency of the appeal, if the order is carried out, the appeal will become infructuous.
All right. Counsel for the appellant points out that against the order dated 30th October 2021. Passed by the Secretary,
PKDA, Secretary, Puri Konark Development Authority.
Puri Konark Development Authority, proposing to demolish the alleged unauthorized construction made by the appellate. An appeal case number
47 of
47 of 2022 was filed in the court of the Commissioner cum Principal Secretary by the appellate. Full stop. While the said appeal was pending, a third party apparently filed writ petition civil 6827 of 2023 without impleading the present appellant as a party, but seeking implementation of the order directing demolition of the unauthorized construction of the appellant. Full stop. In the said writ petition, the impugned order has been passed by the alleged single judge on 15 March 2023. Directing the PKDA to remove, directing the executive officer, Puri Municipal Office, to remove the alleged unauthorized construction. Paragraph. Notice returnable.
I am appearing for respondent 3 minutes.
All right. Notice returnable.
copy has been served. Advance copy has been served.
22nd June 2023, notice is accepted on behalf of respondent 3, Puri Municipality. So notice will now issue to the, and I think Mr. Monty accepts notice for collector.
No, collector is here is the chairman of PKDA. He is, I can take, but
All right.
He
Notice to respondents 1,
is
2, and 4 by registered speed post returnable on the next date. The tracking report will clear record. Then you say till the next date, there shall be a stay of the impugned order.
Ajula, the annexure 9 miles.
It's all right. Yes.
Obliged.
Item number 8.
My lord, may it please your lordships. Is that filling up of, there was a requisition proposal for 959 posts. We have sanctioned about 228 posts. I was only requesting, my lords, that if your lordships can have a committee with the Registrar General, Home Department, and Finance Department and Law Secretary, and earmark the phases in which these posts are to be
Created, is it?
created. Then this,
Wasn't there a committee earlier constituted?
There was, in fact,
if that same committee can look into that.
in fact, here, if my lords would see, they have been taking time.
I know. I have personally looked into it, and I thought it that that in what phases it is required.
All right.
If
I'm told that the government was, there was some hitch because the posts were not being filled up.
No,
But I think that process
Not
is
that.
already underway. So
that is neither here nor there.
All right.
So let them at least clear it up within a month.
No. 900 posts. It's not 1, 2 posts.
But in the first phase, some 424 posts were to be created.
Well, 228 have
494 were to be
220.
created in the first phase.
Well, on 8th of September 2022, Millets, 220. No, I am in your lordship's hands.
No. So which is that committee? I thought we'll.
There's already a committee which they have
That's right.
constituted.
My lord, the committee was the Finance Secretary, the Home Secretary, and the Law Secretary,
With the registrar general.
and the Registrar General.
Ah,
So the same committee can look into it.
All right. The learned advocate general appearing for the state has suggested that in order to work out a phase-wise timeline regarding creation of posts, the committee already constituted in the earlier orders be once again asked to examine the issue and come up with a plan. Paragraph is accordingly directed that a committee of the secretaries of the departments of finance, home and law
Finance, home, law, and my lord, the registrar general.
and the registrar general of this court will meet and come up with a plan for the phase-wise creation of the posts.
Lordship pleases.
A timeline maybe.
That's what. The timeline clearly be indicated and placed before the court before the next date. List on. 13 July is the rent. Where is it? 20 July? 19 July.
Lordship pleases.
Right.
I can share, my lord. This case has traveled from the personal appearance of the Home Secretary and with the Advocate General now.
The personal appearance of the Advocate General.
No, that I never. In fact, the Advocate General has
There
been
should be
kind
some
enough.
humor in the morning.
The order sheets would show that there were a lot of there was a lot of conflict.
But deeply
Earlier,
obliged.
14. That was in 2014.
Right.
Item number 9. My lord, our grievance under answer 2 is pending before OP number 2, my lord. And I have also sent through extra post. Page 24 is the receipt of the postal law.
Petitioner's representation. Bracket direction 2 will be examined by the collector of Baleshwar. And after notice to the petitioners and giving them a hearing, petitioner and giving them a hearing, a reasoned order should be passed thereon not later than 15 June and be communicated to the petitioner within a week thereafter. The court clarifies it as not.
Obliged. Item number 10.
Lords, in 10, Lords, the order of the Honorable Single Judge has already been carried out in the content proceedings. So, my Lords, leaving the questions of law open,
All
Lords may dispose of.
Since the impugned order seems to have been implemented, the questions of law raised in the present appeal are left open for decision in some other appropriate case. The writ appeal is disposed of. The above
Obliged.
terms.
Item 11.
None appears dismissed.
Item number 12.
May I please? Petitioner was a retired Group C employee of Forest Development Corporation and in the present writ appeal challenged the order under Annexure 3 at page 18 of your lordship's brief in not restoring the writ petition which was dismissed for default. And the fault due to the fault of the previous advocate, the writ application of the petitioner was dismissed for default and there was a delay of 362 days. And which was not appreciated by learned single judge, and learned single judge dismissed the application for restoration. In these circumstances, I just want to draw your lordship's kind attention. A person should not be suffered for the laches on the part of the conducting advocate. Petitioner was a Group C employee and working in the Nabarangpur remote district of the Nabarangpur in the Forest Corporation. His mother was suffering from cancer and he was not able to come regularly here. He was not get a response. After that, due to non-taking of the steps by the previous conducting advocates on each and every date, the matter goes unattended and finally the matter was dismissed for default. And secondly, the matter of the said writ application was inquired by the Honorable Human Rights Commission of Orissa, and by Annexure 1 at page 10, Human Rights Commission submitted report that the petitioner was harassed by his authority. he should be looked into. Your Lordship may please to have a glance at page 10 of my present writ appeal.
All right. You say
My lord.
the grievance in the present writ appeal is that by the appeal order dated 16th January 2019, the London single judge has declined to condone the delay in filing the restoration application CMAPL 664 of 2016, which had been filed to recall the order dated (30th October 2015), by which the writ petition civil 46 of 2005 filed by the appellant. Questioning the order passed in disciplinary proceedings, dismissing you from service.
Imposing penalties.
What is the penalty?
Promotion, withholding the promotion for 3 consecutive years and
Yeah.
recovery.
1 minute, 1 minute. Awarding a punishment of stoppage of 1 increment without cumulative effect was dismissed for non-prosecution. Paragraph. The consulate appellant has explained in sufficient detail the reasons for non-appearance of no, where is your CMAPL of 2015? Where is that?
My lord.
Not able to answer.
Where is the CMLPL application?
Yes. Yes. CMAPL 664 of 2019. That was filed in WPC number 746 of 2005. But that was not here in the list. Office not send the said record.
Where is the copy of the CMLPL?
Yes, my. Yes. Reporter. Yeah.
the appellant had explained in sufficient detail in CMAPL. Actually, in this case, this is where is the CMAPL? And in the CMAPL 664 of 2016, as well as in this case number 339 of 2016, filed therein for condemnation of delay in filing the CMAPL. The reasons for his not filing the, not his lawyers, the reason for non-appearance of the lawyer on 30/10/2015. So it appears that after the expiry of the lawyer first engaged, he had engaged a second lawyer who did not keep him updated of the listing and dismissal of the case for non-prosecution. Paragraph. It appears that the explanation offered by the appellant that he had no means of knowing the above fact because he was serving in a remote location. He was serving at the relevant time in a remote location in Koraput. Appears to be a plausible one. Full stop. The court is of the view that a more liberal view ought to have been taken of the question of delay in filing the restoration application. Paragraph. For the aforementioned reasons, the impugned order dated 16th January 2019 is hereby set aside. And this case number 339 of 2016, as well as CMAPL 664 of 2016, are treated as allowed. Stop. As a result, the order dated 30/10/2015 of the learned single judge will stand recalled. Dismissing writ petition civil 746 of 2005 will stand recalled. Paragraph. The above orders in the CMAPL were passed without any notice to the opposite respondents. Stop. Consequently, while setting aside those orders and restoring writ petition civil number 746 of 2005 to the file of the learned single judge, this court directs that the registry will inform the counsel for the opposite parties in the aforementioned writ petition of the listing of the writ petition before the learned single judge in terms of the present order. Paragraph. The writ petition is restored to file. Writ petition civil 746 of 2005 is restored to file and directed to be listed before the learned single judge in the roster bench on 8th May 2023. Since the pleadings in the writ petition are already complete, in the event that the opposite parties do not appear before the learned single judge on that date, notice will be issued to them by the learned single judge for them to appear in the writ petition on the date fixed by the learned single judge. The writ appeal is disposed of in the above terms.
Item 13.
In item 13, I have filed a delay condemnation petition. There is
Copy not sir to me, my lord. Let me first copy.
90 days.
90 days. All right. What's the matter about?
That's matter regarding release of granting rate as per GIR 1994. So we have relied that on judgment that in view of the Repealed Act, they cannot take that benefit of that 94 GIA. So that is the short question here. My lords, gone through that judgment of Arnab Senapati, that in that judgment, lordship has one cannot take the advantage of a repealed act, my lord.
Which is the judgment you are challenging in the present writ appeal?
The impugned order is at page 56. He has extended the benefit granted of 2009. But first was approved with that benefit. So Honorable Single Judge has directed to him, extend him the benefit of 94 credit.
It says, learned additional government advocate does not have serious objection to that course of action. Page 60. Did you file a counter in the writ appeal?
Yes, no counter has been filed, but
Counter was not filed.
Not filed.
I may pardon my lord. I am through BC. I am Mr. S.K. Das. I was the conducting counsel in the writ petition. This is not that case, but he has not served any copy, though we have filed an Baklatnama to appear for respondent 1. Let me.
All right. You just said,
sir.
Mr. Das accepts notice on behalf of the respondent number 1. Notice will go to the remaining respondent returnable on the next date, where is the reports. Tracking report will be placed on record. So, is there any contempt petition filed?
No, my lord, this is not that case. Actually,
No,
this
no,
case has went up from the Education Tribunal to the High Court to the Honorable Supreme Court. And up to Honorable Supreme Court, I have succeeded in the case in 2016. When that order was not, I was not paid my salary, I filed the present writ petition for release of my salary. And the Honorable Court, after contest, this was disposed of in 2019. This is a case of 2016. And rightly, my lord have pointed out the submission of the Land Council appearing for the state. Only the arrear salary is the
I asked you a very simple question, sir.
Yes, my lord.
This order of 2019 by which you had to be paid some amounts, has that been implemented, not implemented?
No. It has not been implemented.
Have you filed a contempt petition?
No, we have not filed. That is the difficulty, because they have given information that they have filed an FAO.
All right.
So we have, sorry, this writ appeal. So we have to wait.
Just simply say, no need for interim order. You see, notice on the stay application. List on 3rd July.
Item 14.
May it please the Lordship. The last occasion, Lordship granted me time to remove the defects, my lord. All the defects are removed except one, that is non-filing of the certified copy of the impugned judgment, my lord. I have applied for the registry. If a lordship may ignore that defect, then I will file a compilation and date chart in this matter, because this matter is involving the Odisha Consolidation Act, Estate Abolition Act, and Communal Forest Alienation Prevention Act, my lord.
All right. Counsel for the appellant needs time to prepare a date chart and note of submissions, and his request list on. 5th July.
Item 15.
Impugned order is at page 41.
First day.
Regarding the
Pendency of criminal case, is that?
only direction has been reached to reconsider the case in accordance with the earlier decision. These are the home guards. Now that we have stopped the engagement of home guards, this is
No, what has happened in these matters? Because this is an order of 2021.
Yes, ma'am, that I have seen that. I'll take instruction on that because
Counsel for the appellant seeks time for instructions on the subsequent developments. List on 4th July.
Item 16.
16, my lord, may be permitted to order file a better petition.
Better petition?
My lord, some documents are necessary to file a better petition. This
petition. This is an appeal, sir.
Yes, my lord, appeal. Yes, this is a transfer brief, and file is handed over to me just day before yesterday, and some documents are missing which are not yet traced. So these are required to file in this writ appeal. Accordingly, I am permitted to order to file a better petition.
Petition or appeal, sir?
Appeal, my lord, yes.
What's the difficulty? You have a problem in distinguishing petition and appeal.
My lord.
No, but why withdraw the appeal? It's a subsistence. You have to file more documents. Why do you want to withdraw the appeal?
My lord.
If you want to file more documents, why do you want to withdraw the appeal?
So that on that basis of that document, some more pleadings is necessary in this appeal.
I don't think we should be giving you free legal advice. That is what you want to do. Counsel for the appellant seeks leave to withdraw the present appeal with liberty to file a better appeal. Disposed of is withdrawn with liberty is prayed for.
Item 17.
In 17, they are not serving a copy of the writ appeal to me after
just now I am serving
specific the order, my lord. And it is filed from 2021. There is no seriousness in listing the matter. My lord, let it come some other day. I will.
Only today, a copy of the writ appeal has been handed over to Ms. Mahapatra, counsel appeal of the respondents, who seeks time to address arguments. List on 4 July.
Item number 18.
18 wala DLR 25th April.
All right.
Item 19.
19, 25th April.
Item number 20.
Item number 20 and 21. That my lordship had taken up this matter on 24th March, my lordship. There are some defect, my lordship directed to remove defect.
On 21st.
Yeah.
21st March, when is that listed now?
It was listed on 24th March, my lordship. My lordship has posted to today because there are some defects, there are 3 defects. I have already served the copy on the central government. Other 2 defects that I could not because the file was in the list, my lordship.
File was?
6.
There are other 2 defects. That is some discrepancy with regard to the name. The time we approach the section, that file has moved to listing section. That's why I could not.
You're so casual about it.
By tomorrow.
Not serious, no, sir. Nothing serious about. Obviously, nothing serious.
Yes, and obviously, yes. That is also partly we are also responsible.
Counsel for the appellant agrees that there is nothing serious in these appeals.
No, my lord. That is also.
Do not entertain it.
My lordship, kindly see, this is this matter, my lordship. We have challenged this matter with regard to transportation charges, my lordship. They are claimed that will be paid at the lead distance of 6 to 7 kilometers. That claim. We have paid them as 5 to 6 kilometers on the basis of study by the Industrial Engineering Department. In this matter, we have taken, we have challenged in the appeal on 2 grounds. First, with regard to maintenance of the writ petition. My lord, you kindly see the writ petition of the cause title. All the Mahanadi coalfields was not made a party. In that aspect, we have also.
Chairman come managing director means
yes, that is chairman come managing director is as the officer
you have
of
separate counsel for chairman managing director, separate counsel for Mahanadi coalfields.
Because he's an officer, my lordship.
No.
There are
I'm asking you a question.
Yes.
Separate counsel for chairman, managing director, separate counsel for Mahanadi Coalfields.
No.
Same person only will appear. What is this point? Any other serious point?
Because there are two judgments, my lordship.
For what?
There are two judgments, my lordship.
For what? What judgments for what?
That in that case, there was first matter. There is a case of termination by the general manager. General manager was made a party. That court has said that since the union government minister of railways is not a party who is the employer,
yes,
the REIT is not maintainable.
Yes.
That judgment, my lordship, went small judgment 2-3 days thereafter, another 2014 judgments, two judgments passed.
Apart from this, you have no strong point.
Apart
from this one point, you have no other point.
That secondly, with regard to merit, my lordship. Can you see, my lordship, annexer, that is impugn order at annexer 1, my lordship. That this honorable one aspect I have with regard to objection that didn't accept. With regard to the merit, my lordship, the honorable single judge has based on a report who was not accepted by the competent authority. In the writ petition order was challenged annexer, my lordship. Annexer 1 of the writ petition was under challenge, my lordship. Annexer 1 of the writ petition has page.
All right. Did you say notice to the sole contesting respondent? Returnable. July 17. Notice on stay. Defects be cured in the meanwhile. Same.
2021 minutes, similar minutes.
None appears dismissal.
My lord, item 22, my lord, petitioner challenge the honorable single judge order dated 17/8/2022, my lord. Honorable, during passing order, honorable single judge not seeing any anything, my lord, even if post is vacant without requisition, government not fill up the post and issue a notification 2012. There is a notification that direct recruitment before that resolution, my lord, government, my lord, kindly see one. My lord, before 2013 resolution, government required the diploma engineer in employment basis, my lord. But at that time, government 2773 post as vacant. Government not fill up this post, my lord. Sir, honorable Singh not see this not seen this anything pass a judgment, my lord.
Have you drafted this writ appeal yourself?
My lord? No, my lord. No, my lord.
That is so obvious, sir.
Yes, sir.
So how did you prepare for this case? Who drafted the writ appeal? Somebody else.
Yes, my lord.
What happened to that person? Council drafted it or somebody drafted it?
No, council draft, my lord.
What happened to that council? No longer there.
My lord, kindly one time to I prepare fully, my lord, with the death charge sheet, my lord.
Counsel to the appellant states that since he has not himself drafted the appeal, he needs some more time to prepare and address appeal. Let's talk. July 17.
Item number 23.
My input order is at page 13, my. What has happened in this case? These persons were retained with effect from 31/7/2001. They approached the London State Administrative Tribunal. The London State Administrative Tribunal granted status quo of 30/7/2001. So that was till 1st August 2001. Thereafter, they have not worked. The Honorable Single Judge has directed to pay them salary during that period as they have continued by virtue of interim. So there is no continuance after 1st August 2001. And that original application was disposed of. Main original application was disposed of. That was direction was that and it's the police decision, your lordship, case 19 is the police decision. On the basis of that, we have retained them.
They only want salary for the period they worked, sir.
They have not worked after 2001. After 31/7/2001, they have not worked. If they have worked by virtue of interim order, they are entitled to the salary.
They have not worked.
They have not worked. That is,
but the status quo order was there.
Status quo order was there. But what has happened? The first status quo was granted on 30/7/2001. So that status quo order was till 1st August 2000. That in that way, original application, they have annexed that document. It can be found from annexure 3 of that original application. That order was till 10th August 2001.
No, but here there's it has kept continued from time to time.
They have not continued after that. I admit that if they have continued by virtue of interim order, they are entitled to. But
because the learned single judge notes in come to page 16.
Yes, ma'am.
Third paragraph, considering the contention raised by the. Just read that.
And the tribunal passed the following considerations are made by learning for both the respondents are directed to allow the applicant to continue in the work.
No, page 16.
Sorry.
Page 16, third paragraph. Considering the contention.
Yes, madam. For the after going through, there is no dispute that by virtue in the past by the tribunal, the petitioner were continuing till 10/8/2001. Till
no, read on.
And as such, subsequently, the said interval of status extended from time to time, and also has taken care of the two while passing.
That's not correct.
But in fact, they have not continued after 10/8/2001.
This is not continued.
Yes, madam. After 10/8/2001, they have not continued.
Although you are appearing for the respondents. Counsel to the appellant submits that the statement in the noting in the impugned order that the status quo interim order of status quo passed by the Odisha Administrative Tribunal, by virtue of which the respondents will continue in service till 10th August 2001, was continued, was single quotes extended from time to time, unquote, is factually incorrect. Full stop. According to him, the said order was not continued beyond 10th August 2021. 2001. Paragraph say notice returnable 17 July. There shall be an interim stay of the impugned order till then.
Item number 24. Item 24.
I think this is the SS Rao. Coming up on 24 July.
On behalf of him, my lord.
Yeah, 24 July, we're adjourned.
Yes, ma'am.
Same on 25 also. 25, 26. Same.
24, 25, 26, 28 and 32.
28 and
32.
32. All right.
Item 27.
27 similar matter notice has been issued and posted to 12th July.
Take that same one. Yes.
Item 29.
Here, the appellant before your lordship is a landless and homesteadless person, my lord. He has filed a writ application with a prayer that he shall not be evicted because he is occupying a government land. His application before the Honorable Single Judge that he shall not be evicted without following the due process of law, my lord. Because of the fact that for the self-same land, they have initiated an encroachment proceeding against another person. That's why, my lord, only limited prayer that he shall not be evicted without following the due process of law, my lord. They have to initiate an encroachment proceeding against the petitioner so that the petitioner can take, my lord, please, that he is a landless person. Second, my lord, the land can be settled in the 8A of the appeal act. That provision, my lord, could not be availed by the petitioner because there is no proceeding against him, my lord. That's why, my lord, they have initiated proceeding against a wrong person. For which, my lord, I have come before this honorable court.
What proceedings have they initiated against you?
My lord, there is no proceeding. They have initiated a proceeding relating to the land in which the petitioner is in occupation against a wrong person. That's why, my lord, my prayer before this honorable court, let a proceeding may be initiated against the petitioner so that he will be evicted, my lord. Initiating a proceeding against a wrong person and order of eviction will be passed, my lord, the petitioner will be evicted. The only limited prayer, my lord, he shall not be evicted without following the due process of law.
If your lordship will see the last para of the para 6 of the impugned order, the honorable court has held that this writ petition is premature. If you say that no proceeding is initiated against me, it is initiated against a wrong person.
No. See, land is X.
Yes.
Okay. Y is occupying that land.
Yes, ma'am.
Notice is issued to A, not to Y. Against A, eviction order is passed.
But that can be enforced against the petitioner if it is not.
Should Y wait for Y to be thrown out and then come to the court saying they've thrown me out, or Y should come to the court and say, I am the person to whom notice should be issued?
My lord, so far as the petitioner is concerned, if there is no eviction order against...
Oh, suppose the record...
That is the view of the honorable.
No, in their record, they say A is in occupation of the land. We have issued notice to A.
Yes.
We have heard A. Now we are evicting A.
Yes, ma'am. But he is in possession.
No, Y says A was never in possession. I am in possession. By saying that Y A is in possession, you have now passed an order against A. On that pretext, you are evicting me.
Then that order cannot be applicable to be.
That's right. When will Y go and show that? After being evicted or before being evicted?
Then if in that case, he can intervene in that application.
So at least that should have been permitted then.
Let the petitioner intervene in that proceeding and say, I am in possession, he is not in possession.
Lordship will kindly see if I will intervene, I will not get the relief as provided under the appeal act.
That is a different proceeding.
If they have to initiate proceeding against me, I am a landless person, I am a homesteadless person, my lord. I am residing there. let them, my lord, evict me by following the due process of law. That is the only prayer before this honorable court, my lord.
Okay, who's the person against whom they evict?
Yes, that is
Who's
also,
that person?
he is not made a party. That is also another contention which I
You should
want
not
to
become another thing of
Yes.
you getting an order without him knowing.
He
You
will
don't know whether he's an occupying.
It will be a
one
surprise
portion
to
or
him
not.
also again.
Who's that other person?
No, he has not.
Who's that other person?
It is only the allegation in the writ petition.
No,
but he has not been included.
that is not the allegation. Your lordship will kindly annex 5, page 18.
Why don't you make him a party?
Party, he's not party.
My lord, this state, if your lordship will hold that I shall not be evicted without following the due process of
That other
law.
person also should know. See, ultimately, he's also somewhere part of these proceedings. What has happened to those proceedings against him?
My lord, they are, my lord, they have passed the order of eviction.
And he has not challenged it.
No.
There is no.
So why he will appear? Why he will, my lord, participate in the proceeding?
But that order, I think that is not annexed, that it is passed against, that has to be annexed to show private basis.
So technically it is one.
No, it is not a technicality. It is a-
I shall not be evicted without following the due process of law.
That blanket.
Let them initiate a proceeding against me.
Anyway, you say notice, you find out what the factual position is.
Yes.
Notice is accepted by Mr. D.K. Manthi, counsel on behalf of the respondents.
And I pray my lord status code on
Yeah, status quo. The respondents will ascertain what the factual position is as regards the occupant of the land in question. And the status report will be filed before the court on the next day. List on 17 July, status quo we maintain till then.
And the same order in item number 31, my lord.
All right, 31.
Item number 30.
Outsourcing mail 8th August.
All right. Item number 33.
33 mail. The limitation of 700 days.
700 days. Okay. There's a delay of 700 days in filing the present appeal. But what's the date of the impugned order?
2018.
So even COVID does not help you. The impugned order is dated 3rd April 2018, which is prior to the COVID period. The delay of 1668 days in filing the appeal. The impugned order being passed on 3rd April 2018 by the learned single judge. Even the benefit of the COVID-19 period does not help the appellant to explain the extraordinary delay. Paragraph. Consequently, the court is not inclined to condone the delay. IA number so and so is dismissed. Consequently, the appeal is dismissed.
Item number 34.
35 mail rehabilitation 30th August.
30th August.
Item number 35.
35, I pray 2 weeks time to file counter. Sorry, rejoinder.
No need for the writ appeals.
Millard, counter is filed by the OP number 1. I pray 2 weeks time to file rejoinder.
It's all right. Tell us what the matter is about.
Millard, Mr. S.S. Das, senior advocate, is to argue the matter.
All right. We'll pass it over.
Millard, he is not in good health. Let it be next week, any day. Next week, any day.
It's surprising. Who's for the respondent?
State. State.
Sir, have you filed an appeal against the conviction order?
Yes, that is pending adjudication before this honorable court.
What is the criminal appeal number?
That is, I'm supplying 113 CRLA 113 of 2019.
And do you have a bail in that?
Yes. 113 of 2019.
So you are on bail or in that case or not, in that appeal?
That, but my client is not in custody or prison. He's out of. So he is on bail.
You're not the conducting counsel. You're not the conducting counsel.
No, he is on bail.
No, you are not the conducting counsel.
In that vigilance case.
Yes.
So 3 people have to ask you a question for you to understand. This is remarkable. Remarkable.
Sorry.
Now the 4th person is asking you, see. And all of us are speaking on mic.
In the lower court.
This is a remarkable thing. What has happened? You didn't sleep well or something?
Sorry.
No, don't have to be sorry. How many people have to? In this year, Mr. Monty is feeding you, and that now Mr. Kuntaya.
Sorry, I could not follow that. My fault.
You have not understood anything. Are you the counsel in this matter, or somebody else is handling, and you are simply asked to go and take adjournment?
In the lower court, in the High Court, Mr. S.S. Das is the conducting advocate. In the trial court of vigilance case.
So you're only adjournment advocate.
No, that is not that.
No, I'm asking. Many advocates who specialize in this, sir. You're a seasoned man. Some are adjournment advocates, specialized only in that.
No.
You see, they come itself, that adjournment advocates will have a long face. They can cry. Have a pitiful face. Kindly adjourn.
I am misunderstood by your lordship.
Some specialize in adjournments.
No, because the client has engaged senior advocate. So
engaged you for adjournment.
Naturally.
You are specializing in adjournment. All right.
Any day next week. Mr. Das is
where you put this in your voice, that modulation is. People watching should know.
I am sorry.
This is also an art. Taking adjournment after adjournment is an art.
That is to be my duty under a senior counsel.
No, but you have not drafted this appeal. Somebody has drafted. You have not drafted.
No, I have.
See, I'm seeing both your hands like this. Normally, advocates will hold some paperwork.
I have drafted, my lord.
But you have left it behind in your chamber. See, look at you. You have no
brief. Brief is here.
So have it here, sir. Little, at least let us know that you're serious about the case. You drafted it or somebody drafted it?
I drafted.
I see. Because so many questions we have to ask to get you basic facts. In this appeal, have you taken a ground that criminal appeal is pending?
Yes.
Where is that? Which is that ground?
Para 8.
So today we are going to change you from adjournment advocate to arguing advocate. We say notice. Mr. Kuntia accepts notice on behalf of. You give the bad news to Mr. Das that, sir, I went only to ask adjournment, but the court granted notice.
I am grateful, Mila.
He accepts notice on behalf of opposite party respondent number 1. Notice to the remaining respondents returnable on the next date. (19th July). 19th July. All right.
Much obliged, Millards. I may not be misunderstood, Millards. That was my part of duty.
That's the duty you want to change a bit.
Client would misunderstand. Sorry.
That's all.
Item 36. I have given the similar order.
Never. Dismiss.
All right. Same.
Item 37.
37 was job count of 14th September.
14th.
Item 38.
38, 39, 40, 41. All are job contract. 14th September.
14th September.
38 to 41.
Yeah.
Item 42.
Ma'am. Matter relates to recruitment of constable manner. And as per the notification on page 240 manner. Notification dated manner 18/1/2002. As per the notification dated 18/1/2002, 10% of Home Guard category candidates shall be kept reserved for excise constable manner. But the
What is your claim? You're a home guard.
Home Guard man. As per the notification, that notification, 10% should be kept vacant for Home Guard category candidate to be appointment as excise constable.
Where is that notification?
Page 40, my lord.
Page 40. "10% of vacancies occurring in the rank of excise constable may be kept reserved for eligible home guards." All right. Then what happened?
In an advertisement was issued, but nowhere it has been stated for 10% vacant for Home Guard category, my lord. I approve your lordship. I approve the London Tribunal, and thereafter your lordship has passed the order, honorable single bench. Since the rule thereafter a rule has come into force, and in that rule there is no vacancy for Home Guard category candidates, you are not entitled to get, man.
When did that rule come?
They have enclosed in the counter, my lord.
Page 47,
my lord.
Lower excise service method of recruitment conditions. It's a 2011.
Yes, ma'am.
11.
But how do you apply retrospectively that rule, sir? This recruitment happened in 2002. When did the recruitment happen?
No.
2015, my lord.
2015?
Yes, ma'am.
Oh, I see.
2014.
There is also no stipulation in the rules.
The rules, if it's not there, you cannot go back to that instruction.
Yes.
Rules will apply.
Yes, ma'am.
You see, the challenge in the present appeal is to an order dated 28th October 2022, passed by the learned single judge, dismissing the appellant's writ petition civil (OAC number 1205 of 2015). Paragraph: the prayer in the said writ petition was for a direction to the opposite parties, the respondents, to appoint the appellant, who is working as a home guard, as excise constable, following the reservation policy of 10% for home guards. Paragraph. In support of the above plea, the appellant had placed reliance on A letter dated 18 January 2002, written by the Deputy Secretary to the government. In which department? That is not clear.
Home Department. Top special secretary to the government Home Department.
That is it addressed to him, sir. It is from this Deputy Secretary.
It has not been clearly mentioned.
A letter dated 18 January 2002 of the government of Orissa. Conveying the decision of the government to earmark 10% of the vacancies in the rank of excise constables for eligible home guards. Paragraph. However, as stated in the counter affidavit filed in the writ petition, in 2011, the Odisha Lower Excise Service bracket method of recruitment and conditions of service bracket rules 2011 was issued and came into force on 8 June 2011. Stop. These rules did not provide for reservations for home guards in the post of excise constables. With the writ petition having been filed in 2015, the earlier instruction of 18 January 2002 was no longer applicable, as it had been replaced by the 2011 rules. Paragraph. In the circumstances, the impugn order of the single judge declining the relief prayed for in the petition cannot be faulted. No grounds are made out for interference. The writ appeal is dismissed.
Item number 43.
43, my lord. In similar matter, my lord, already.
Your Lordship has already dismissed.
Dismissed, my lord.
All right, I have given that.
In view of the order passed by this court.
43 and 45 said.
On 4th April 2023, in writ appeal 1321 of 2022, bracket State of Orissa versus Vijay Chetan Vidyaadhar Sahu. The present writ appeals are dismissed.
Let me.
Item 44.
May I please, Your Lordship? Lord, I have challenged the impugn order passed by the single judge, Lord, which was passed ex parte. The appellant before Your Lordship is the financier, and that order was passed ex parte directing us to release the vehicle on payment of 50%. And Lord, on 3 issues, Lord, ground I have challenged this order. First is the single judge is recorded in the order that writ is not maintainable.
And yet he is given the relief.
Yet given the order, and Lordship may kindly see page 59, the RBI is asking us, saying that on receipt of a part payment, we cannot upgrade the account.
All right. We say notice returnable. Is anyone appearing? No. So you have not released the vehicle yet?
Not yet.
Any contempt pending?
My lord?
Is any contempt petition pending?
No, my lord. Contempt was pending in this case. But no order is passed or anything received by us.
All right. Notice returnable, 17 July.
File an application.
Tracking report be placed in record. Till the next date of hearing, there shall be a stay of the impugn order.
46 is the same, Lord. 46 item is identical.
Right. Same in 46. All right.
58, 59, 60, I'm withdrawing this appeal because borrower has released the vehicle.
All right. 58, 59, 60. Since the borrower has already released the vehicle, the present appeals have been rendered infructuous. and it's disposed of. As
Obliged.
Item number 47.
45 is same as of 45. That's same.
Over. Item 47.
But regularization contractual driver, that your lordship has fixed to 11th July.
11 July.
It's a first day disposal means what I pray, it's a first day disposal. Let it be remitted back to the honorable single judgment.
All right. Inasmuch as the impugned order was passed on the very first day without any opportunity to the present applicant to file a reply, it is hereby set aside and writ petition civil 29126 of 2021 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 3rd July. The replies be filed, Parav's reply be filed by 22nd June and rejoinder for 3rd July. No further time will be granted to either party for that purpose. The learned single judge is requested to proceed to hear the writ petition on merits and dispose it off as expeditiously as possible.
Grateful.
Item 48.
13th September.
14th September. All right.
Item 49.
May I please, your lordship? This appellant being aggrieved to the order of honorable single judge under Annexure 12 has filed the present writ of appeal, praying for quashing of the same with other consequence reliefs. The order of dismissal under Annexure 9 was under challenge before the honorable single judge was tribunal, and subsequent period that was transferred to High Court, and that was challenged and a prayer was made for quashing of the same because that order of dismissal was passed by the authority invoking Rule 18 of OCS CC Rules 1962, basing upon the conviction of this petitioner in a vigilance case wherein he was falsely roped in. My contention before the honorable single judge was, on the basis of conviction, the service of petitioner could not have been dismissed straight away. If at all the authority decided to invoke Rule 18, they wanted to dispense the procedure which is laid down under the CCA rules in support of protection of the employee, then under the Rule 18, certain contingencies are there. The authorities should have arrived at a finding that these contingencies are fulfilled. Therefore, order of dismissal is required to be passed. And that order was absolutely illegal. That was called in question before the tribunal, before the honorable single judge, and prayer was made. This order is not sustainable in view of the following reasons. Natural justice violated, actions involving civil consequences have not been taken note of, and Article 21 involving right to livelihood has been taken away without following due procedure of law. And this matter was not rightly considered, and the honorable single judge on Annexure 12 has said that since basing on order of conviction, the order of dismissal has been passed, no illegality is found. This order is absolutely illegal. I shall take a lordship. Rule 18 of CCA rules. Under this Rule 18, the government is having power to dispense the special procedure laid down under the rules. I am reading out that three contingencies are provided. The first contingency is where a penalty is imposed on a government servant on the ground of conduct which has led to his conviction on a criminal charge. This is the first contingency.
Where have you set out Rule 18?
Rule 18 of Orissa.
Where have you set it out?
Yes, my lord, I have. Your lordship can turn to page 20 and 21 of my case. Miller. Yes. Miller, I'm just in the middle of the portion. It is started. I'm just reading the entire paragraph of paragraph 4, page 20. For that is needless to say, the order of...
Sorry, sir. Sorry to interrupt you.
Yes.
I want to read Rule 18.
Yes, Miller, I'm just reading. I was reading that.
No. I want to read. You reading is one thing. Is it okay for me to read or I should not read?
Your lordship, your lordship should do.
I should also read, no?
Your lordship should do.
How will I read unless you show me a copy of Rule 18?
That rule. The book is available.
when we used to draft petitions, we used to, because the whole case is based on this rule 18, correct?
Yes, Lord. Yes, sir. I have
So
doubt.
we would, I mean, maybe your style of drafting is different from mine. I would set out that rule 18 prominently.
Should have been
in the appeal.
Yes, Miller. Miller, I'm reading out. May I read out?
So that sub rule 2 says there should be a recording why it's not practicable to follow the procedure.
Yes, Miller. But Miller, in my
that recording is not here.
Miller, in my case, by resorting to Rule 18(1), that where a penalty is imposed on the government servant on the ground of conduct which has led to his conviction on a criminal charge. Basing upon this, my conviction in a vigilance case, this order of dismissal on Annexure 9 has been passed. Miller, my entire submission before Lordship is that in the input order on the Annexure 9, there is no finding at all by the opinion number 1 who has passed the order that his conduct has led to his conviction in the criminal vigilance case. When there is no such finding, how the order of dismissal could have been passed? It could not have been passed. Because the Rule 18 provides 3 contingencies. They have resorted to Rule 18(1) because by invoking Rule 18...
The conduct he's talking of is the conduct which is there in the charge sheet on which trial has happened.
Miller, they have to reach a conclusion. They have to arrive at a finding that my conduct in the vigilance case, because the vigilance case has led to my conviction. Because that conviction is under challenge before this court in appeal.
There's no stay of conviction, sir.
No, Miller, that is a fact. There's no dispute over it. But my entire submission is that what the authority was to do, the authority was to record a finding under Rule 18(1) that the conduct of this appellant convict has led to his conviction in the vigilance case for which dismissal is necessary.
Let's read that. Let's read that dismissal order.
You also can see Annexure 9.
Yes.
That the input order at page 40-41, Miller.
Yes.
Yes, Miller. Miller, these are the facts only stated. I'm just reading out the last paragraph. The fourth paragraph from page 40, and then after I will go to the next paragraph. Whereas CTT Gupta, ex-accountant head clerk, has preferred and appeared before the Honorable High Court of Orissa against the judgment and order passed by the Special Judge Vigilance Cuttack in their case number so-and-so, arising out of Cuttack Vigilance case number so-and-so on dated 16/8/10, the Honorable High Court of Orissa in case number so-and-so passed an interim order that fine imposed by the special judge shall remain stayed to dispose of the criminal appeal. Further, the miscase number so-and-so, the Honorable High Court has also passed an interim order that the person is directed to release and bail as such terms and conditions as deemed just and proper by the special judge vigilance. Both the orders of Honorable High Court passed miscase number so-and-so was examined and found that the government servant is not free from conviction. As such, allowing the convicted officer to continue should impair the morale of the other persons working in the department and also erode the confidence of the people in other public servants who would either be colleagues of the convicted person, my lord. Then thereafter you also turn to the next page. Whereas the matter was moved to government in MSME department seeking the clarification regarding dismissal of Sri Gupta, accountant, wherein law department has clarified that once a government servant is found guilty of corruption, unless order of conviction is set aside, he cannot be allowed to continue in office. Under circumstances, the request of J Department for dismissal of Sri T.T. Gupta, accountant cum head clerk under section 13(2) Redu 13(1) CE of PC Act 1988 and to undertake a special procedure as prescribed Rule 18 of CC Rules 1962 justified. Hence, considering all the aspects cited above, T.T. Gupta, accountant cum head clerk, yes, report dismissed from government service with immediate effect, my lord.
No. How are you making the case? The conduct is already discussed. In the very first paragraph, It says for demand and acceptance of illegal gratification.
This discussion does not satisfy the requirement of a law. My submission is that when three contingencies are provided by the rule making authority under the rule,
there must be some decisions that have interpreted Rule 18.
Therefore, they are required to arrive at a finding, particularly that yes.
He's not understanding. Is there any case law that supports this point?
Is there any case law which supports your points of argument?
Yes, my lord.
Please show.
My lord, in some cases, of course, today, unfortunately, because of some difficulties, I have not been able to bring the books. But I have.
So today is not the good day then. Today is not the good day.
No, that is not, my lord. That is not.
Which day do you want?
Because I was under
which day do you want? Which day?
Another case.
You don't want. You want another date.
Yes, my lord.
Case. Counsel for the appellant seeks time. This should have told us long ago, sir. Seeks time to praise copies of the decisions he wishes to cite in support of his submissions.
Yes, my lord.
At his request list on 24th July.
Oh, right. Item number 50.
Contractual regularization 11th July.
Okay.
51.
51 also 11th July.
Item 52.
11th July.
All right.
Item number 53.
53, 54, 55, 56 and 57. 14th September.
All right.
Item number 61.
61 was 11th. That 11th May.
11th May.
No, I'm giving the call.
All right. Same order.
Item 62.
62. 14th September.
Item number 63.
25th April.
64.
64 my lord Sartapada 8th May.
Item 65.
My lord 65 and 66 my lord RA appointment posted to 30th August.
Item 67.
Sartapada 8th May.
May.
Item 68.
May I please? This appeal is directed against the order of the single judge at Annex 1, page 21.
Annexure 1 page?
Annexure 1 page 21. Madam.
Yes.
And this original application filed before the London Tribunal, which was transferred to this Honorable Court. And in that, the order of challenge was at page 62, madam. Termination order. The petitioner, the appellant was terminated without any notice. Is page 62, madam. Order dated 31/1/2017. By this order,
yes, you had filled up the column wrongly. There was a pending criminal case against you.
The criminal case was pending against me, but the
you said
allegation
no.
was,
Instead of saying yes, you said no.
Yes.
Then
that is an admitted fact.
But
They said that I suppressed it.
Naturally.
Now the question is whether I have suppressed it or not. That is what I submitted before the learned judge. Had an opportunity been given to me, no notice was given to me that this order was passed unilaterally. Now the problem is, my lord may see the application which I submitted. This was an appointment under rehabilitation assistance scheme, and there was a prescribed form under the rules. So the application form which I submitted is page 96, my lord.
Yes.
In that, my lord may kindly see the application form which I submitted.
Yes.
So whatever information was required to be submitted under annexure under that form, this was a prescribed form under the rule. So I submitted. So there is no column in this to disclose that.
No. Column 12, sir.
My lord.
Page 99.
Page 99, yes, my lord. That is what? Page 99 is the attestation form at the time of joining. So para 12, yes, my lord. I have para 12 is that whether you are convicted or not. I was never convicted. Only criminal case was pending. So now they say that you have said no, because the question was whether you are convicted or not. I was never convicted. In that case, I was acquitted subsequently, of course. Now, no opportunity was given to me. I was now my learned single judge, relying upon the decision, my lord may kindly see para 8, the decision relied upon by the single judge of the order, my lord. That my lord single judge, learned single judge quoted the decision. I have annexed the decision under annexer. The entire decision I have annexed. And the facts of that decision, cited decision, my lord, relied upon by the honorable single judge, that is a decision of the High Court of Andhra Pradesh. The facts of that case is different. In that case, my lord, there was an advertisement. In the application, there was a column to disclose about the pendency of a criminal case, and the applicant did not disclose. So on that ground, his candidature was set aside.
Right. All right. You just say notice returnable. You accept notice, sir?
Yes.
For the respondents. Before that, you say counsel for the appellant has drawn attention to column 12 of the attestation form, which was required to be filled by the appellant at the time of appointment as peon under the rehabilitation assistance scheme, which only full stop, the said column requires the applicant to disclose whether he has been convicted of an offense. Full stop. Inasmuch as the appellant at the relevant time had not been single quotes convicted, but was facing trial in a criminal case which had not at that point come to a conclusion, the answer given by him was single quotes, no. So it is contended that this does not amount to suppression of a material fact, and that subsequently the appellant was in fact acquitted in the very same criminal case. Paragraph. Then you say notice, he accepts notice. List for final hearing on 25th July.
Item number 69.
Item 69, rehabilitation, 30th August.
30th August.
70, 71 also, sorry, 70, item 70, rehabilitation.
Rehabilitation, 30th August. 71?
71 of 14th September.
14th September.
Item 72.
72, 14th September.
All right.
73.
Yes, sir. Yes, Your Lordship.
May I please, Your Lordship? My lords, am I audible, my lords?
Yes, yes. You're audible, not visible.
Yeah.
Now you're visible.
Yeah. Thank you.
Yes.
Well,
Yes.
This appeal has been filed a little belatedly because it arises out of a OGLS matter, and in the settlement proceeding, despite order of the ADM, the settlement officer recorded the land in government khata.
This is AS Narottam Ratha.
Yes, my lord. It's covered by Narottam Ratha's case.
All right. If it is covered, Mr. Monty is here. It's covered or not? Or should we send it back to the single judge?
Yes, ma'am.
To consider if it's covered? If you say it is covered, then we'll might as well.
Yes, ma'am.
There is this appeal. You said for the reason stated, the delay is condoned. The present appeal is directed against an order dated 4th April 2018, passed by the single judge, dismissing the writ petition as not maintainable on the ground that the appellant has an alternative remedy of filing a revision under the Survey and Settlement Act.
Yes, Odisha Survey and Settlement Act.
Orissa Survey and Settlement Act. Paragraph. At the time that the impugned order was passed, the order of this court, dated 31st January 2023, in writ petition civil 1608 of 2014, Narottam Ratha versus State of Orissa, had not been pronounced. Full stop. That judgment answers the question in favor of the present appellant, namely that the Assistant Settlement Officer under the OSS Act could not have suo motu at the stage of considering a request for correction of the record of rights entered the name of the government. Full stop. The court has clarified in the said judgment that the setting aside of the order of the ASO would not preclude the government from proceeding under Section 3, capital B of the OGLS Act. Paragraph. Following the judgment in Narottam Ratha Supra, this court sets aside the impugned order and directs that the appellant's name will be entered in the ROR as prayed for, while at the same time reserving the liberty of the government to proceed in accordance with law under Section 3, capital B of the OGLS Act. The appeal is disposed of in the above terms.
Item note 74.
74 my outsourcing.
8th August.
8th August.
Item 75.
So I'm appearing for the respondent notes. Here, my lords, subject to what my learned friend submits, there's a delay of 340 days, my lords.
But COVID period, I think.
Sorry?
COVID period, the Supreme Court order.
No, but this is not a COVID period, my lords.
Why?
My lord, here, my lord, the order is dated 15 to 2022, my lords.
22.
And my lords, if your lordship to take up flag A, that's a delay condemnation petition, my lords. They do not say anything about the COVID period.
I know they don't.
And your lordship see,
the Supreme Court's order came, I think, extending the COVID thing came with the
so
end
that
of
has not
period.
been that has not been specifically pleaded, no. I only place paragraphs 3 and 4 of that delay condemnation.
First June.
You know how it is.
Okay, my lord, I bow down, my lord. Essentially, my lords, what transpires, my lord, the grievances, my lord, about since I am appearing for the respondent, my lord, I'll be taking the liberty from my learned friend, my lord.
Right.
Only
The
I'll
date
draw
of-
my
only to
four
the
dates,
extent of
I can draw my lord's notice only 4 dates. What has happened, my lord? In 1977, he acquired the bead qualification. In 1978, he was promoted to the post of third master. In 1988, that I'm giving the dates, 8780, he was granted the third master scale of pay. On 30/11/2008, he retired from service. So in 2011, he approached the Learned Tribunal to grant him TGT scale with effect from 78. So that's a claim after 38 years. And we have granted them headmaster's care relying on the policy decision of 1980 policy decision. So that's a state, our only grievance before mile, that's a stale claim that cannot be entertained after 38 years. This is
here, sorry. Look, the learned single judge, he says that the payment is a continuous cause of action, Lords. And there, the appellant here, my lord, they rely on Tansim Singh, my lords. At best, my lord, may I just pass on that judgment of the Honorable Supreme Court, my lords. They refer to that judgment, my lords, but all the same, that's why, my lord, the only grievance, my lord, which I must humbly pray that your lordship should consider. At page 16, they refer to Tansim Singh, my lords.
This is disability pension stands on a different footing.
No, this is not a disability pension, my lords.
No. Tansim Singh.
No, Tansim Singh, my lord, what has happened, my lord, at best, my lord, here, my lord, what the learned single judge has done, my lord, he has given me, as per the judgment of this honorable court, from the date of acquisition of B.Ed qualification.
No. I'm saying Tansim Singh is a disability pension.
Is a disability pension. And this, my lord, your lordship would see, my lords, what they have done, my lord, they have held at page 651, my lords, if your lordship would see, my lords.
Yes. Restricted to 3 years.
3 years before the date of filing, my lords. So keeping the man, my lord, who is now about 75 years.
But is this like, I don't know whether we can draw a parallel with this.
No, what I was trying to humbly submit, my lords, since he approached the learned tribunal in 29/9/2011, my lords, at least, my lord, the benefits can be given to him from 29/9/2008, if not from 8/7/2077, that is the date of acquisition of this trained graduate qualification, lords. And the fact remains, my lord, that is a continuous cause of action, lords. And that is what the learned single judge, my lord, he has also.
Is it a continuing cause of action? That's the only question.
My lords, your lordship would say, my lords, that this learned single judge has dealt with that matter at page 59.
Pay has been
page 59.
Everything.
Page 59. No, he'll be getting some additional pensionary benefits. He has already retired from service. Paragraph 7, my lords. 1, 2, 3, 4, 5, 6, 7, 8, 9. No, 9 lines from the bottom of that paragraph, my lords.
Yes.
Non-extension, lord, you got
yes.
Non-extension of such benefit amounts to discrimination hit by Article 14 of the Constitution of India. The contention raised by the Learned Standing Council for School and Mass Education Department that the petitioner approached this court after 33 years for claiming the fixation of scale of pay, thereby the application hit by delay and latches.
No, it will continue as long as he's in service.
Lord, he was in service.
No, when?
My lord, he retired from service, my lord, on 30/11/2008.
2008.
My lords. And my lords, thereafter, my lord, he made representation. He approached the tribunal on 29/9/2011, my lords. All that I was praying, my lord, to be fair on the state, my lords, the lordship may modify that order restricted to 3 years before he approached the tribunal, my lords. Because ultimately, my lord, his pensionary benefits would only be enhanced.
No, if it is only for reworking his pension, it's one thing.
My lords.
No, is the relief only for the reworking of
pension? My lord, the relief, my lord, is in view of this
paragraph. So let it be confined to reworking the pension.
Lord, for that, my lord, what they have done, Lord, certain
that is fair enough. I think that we will not object because he has come within 3 years from the date of his retirement. His pension can be refixed on that basis.
After 3 years of the retirement, claiming benefit with from 78.
No. So only for reworking the pension, sir. He won't get actual arrears of all those pay.
I don't claim arrears, my lord. What has happened, my lord? They get, my lord, this career advancement scales, my lord. So let that be calculated, whatever be the pension amount.
That's right.
Pension as on 2008. Let that matter be given from 2008 onwards. At least for
the date of his retirement.
The date of his retirement was, my lord,
2008.
30/11/2008. From till that
date of his retirement, whatever pension, you refix it on the basis of this.
No, they have to, my lords, with great respect, they have to now calculate it by taking into account the career advancement pay till 2008.
Correct.
And thereafter, my lord, let them give it after 2008, my lords.
Correct.
That's 3 years before I approach the tribunal, my lords. And in fact, my lord, that happens to be the only objection which has been culled out at page 3, my lord. They take an objection to the date of this payment, my lords.
So you just say notice, he accepts notice. In that application for interim relief, it is seen that in terms of the impugned order, the appellant is required to refix the salary of the respondent from the initial date of his officiating as headmaster. That is 31/1978, is it?
No, he was permanently appointed as a headmaster.
May I draw on? Your Lordship, I said this will not be precedent for others, because why I am saying so. In 1980, we issued a policy, and as per the policy, we have granted that scale. So once this order is passed, others will come that saying that you give us from the data packet. That there would be a problem.
No, that policy, my lord, was held by the learned single judge that it has no, my lord, relevance. So because it is neither here nor there, my lord. They don't say why they have fixed 8/7 in 1980, in spite of the fact that there were two.
You say from the date, no, 1 minute. From 8/7/1977, the day that the respondent acquired the trained graduate teacher, bracket TGT qualification. Full stop. The ground on which the impugned order has been challenged is that the respondent approached the Orissa Administrative Tribunal with the above plea for refixing his salary by granting him the TGT scale of pay. 38 years after, not 38 years, 34 years, no?
30 years, my lord, when he approached.
77, he acquired the qualification.
33 years.
33 years after he acquired the qualification, and 3 years after he had actually superannuated. So in other words, he superannuated on 30th November 2008, and filed the application in the
29/9/2011. They have not given
28/9 in the OAT on 28/9/2011.
29
paragraph. Counsel of the appellant has relied on the inter alia, placed reliance on the
8th July 1980.
Judgment of the Supreme Court in Union of India versus Tarsim Singh, 2008, 8 SCC 648. To urge that where the claim is highly belated, arrears should have been restricted to 3 years prior to the filing of the application. Full stop. In other words, according to him, there was no justification for directing payment of arrears right from the date of acquisition of the TGT qualification by the respondent, which is from 8/7/1977 onwards. Paragraph. Mr. Kar, on the other hand, submits that the respondent will not claim arrears of salary as long as the respondent's pension can be refixed on the basis of his being granted the TGT scale from the date he acquired the qualification of TGT. Paragraph. Having considered the above pleas, the court directs that the impugned judgment of the learned single judge will be substituted with the direction that the pension of the respondent will be refixed on the basis of his having been granted the TGT pay scale from the date of his acquisition of the TGT qualification. And the reworked pension will become payable to him from the date of his superannuation. Stop. These orders, the said calculation be worked out and the appropriate order shall be issued by the appellant within a period of 8 weeks from today. Stop. As far as the arrears of the differential pension is concerned, it shall be paid to the appellant within a period of 12 weeks. Paragraph. It is clarified that the present order is being passed in the peculiar facts of the case, and the impugned order of the single judge or this order will not constitute a proceeding.
Greatly obliged.
The appeal is disposed of.
Item 76.
May I please, Lordship? My lord, last occasion, Lordship directed me to remove the defect, my lord. I am extremely sorry I could not remove the defect, my lord. My lord, I need at least 1 week time to remove the defect, my lord. My only defect that I have not annexed the original certified copy, my lord.
Last opportunity is granted to cure the defects before the next date. List on. First May.
Item 77.
13th September.
14th September.
78.
I am for the respect. Yesterday, this matter was before my lord's, my lord. That I will draw my lord's notice the charges leveled against the petitioner, sorry, my lord, respondent. Lords, you can find it from Annexure 1 of the original application at page 30.
The squad report, same
Yes,
thing.
yes, that matter.
You're here also saying you give a copy of the squad report.
Yes, but that we have said that we have given a copy of that squad report. He is disputing that has not been served on him. Direct of that squad report, that only the punishment is not only on the basis of that squad report. That I'll draw my lord's notice that Annexure 1.
No. In a similar matter, what happened yesterday or day before?
Yesterday, yes, this has been assumed
today. You were to show me that.
I could not brought the instruction from the government. So if you'll ask me, grant me 7-8 days time so that I can take instruction that with that file, unless I'll submit that file so that, because our letter says all the documents we have that has been supplied to him.
But yesterday he was showing a thing
that page 97. That is the squad report is not existent. The existence of the squad report, my lord, 97. It has been stated, page 97, my lord, second paragraph, fourth line from below. It has been stated in para 2 of the compliance report filed today that the aforesaid squad leaders, that is Srimati N. Biswal, S.N. Patnaik and D.P. Das, ex-special officer, never conducted inquiry into the plantation in Sarat and Dantiama and TRCS and never submitted such report on the aforesaid 2 plantations. In spite of that, my lord, in the next paragraph,
is not ready.
Therefore, instead of complying such order, you are still asking for supply of squad report which does not exist at all. Basing upon this, my lord, the Sarat and Dantiamu TRCS squad report, the inquiry officer found me guilty, page 44 of the inquiry report. Your lordship, page 44 of the inquiry report.
You say counsel for the appearing for the respondent on advance notice draws attention to annexure E. Sorry, annexure 9, is it? No. Annexure E to the writ petition. What is this annexure E?
That is annexure 7E, perhaps. That is annexure
7/1.
Sub-annexure E.
No. Sub-annexure E, that was the page 8 series, annexure 8 series of the writ petition. I have annexed that document, page 97.
Annexure 8.
8 series.
Annexure 8 series, which includes a document dated 2nd August 2011 of the Deputy Secretary to the Government, Textiles and Handloom Department, addressed to the Directorate of Textiles, inter alia stating that
to that respondent.
No, to me, my lord. To me, this is
addressed to the respondent, stating that he was insisting on copies of the squad reports, open quotation, which does not exist at all, unquote. He accordingly submits that the learned single judge was justified in quashing the disciplinary proceedings, which were based on non-existent squad reports. Paragraph, Mr. Kuntia, learned counsel for the appellant, requires one more adjournment to verify the correct position regarding supply of copies of squad reports
of Dantiaman and Sarat TRCS. That two plantations.
Squad report,
Yeah,
which has
squad
been,
reports. Yeah, squad reports itself.
which has been utilized during the course of
The
the
respondent. At his request, as a last opportunity, list on 20th April.
Item
20
number
April.
Item 80.
Item 80.
80.
Sarta parida.
8th May.
8th May.
81.
81 my lord, Varchar, 14th September.
14th
82.
82 my lord, Sarta parida, 8th May.
8th May.
Item 83.
83.
In item 83, I am appearing for the respondents. I have also filed my Bakalatnama, but my name has not been reflected in the cost statement.
Right.
83
Copy of
criminal case, during pendency of criminal case, direction has been given for promotion. As is appearing, this is the first day
First day disposal, all right. In as much as the impugn order has been passed on the very first day without any opportunity to be appellant to file a reply, it is hereby set aside. Writ petition civil 25742 of 2021 is restored to the file of learned single judge in the roster bench, where it will be hearing on 10th July. Reply will be filed. Parav's reply to the writ petition will be filed with the appellant on or before 3rd July, and the rejoinder thereto on or before 10th July. No further time will be granted to either party for that purpose. The learned single judge request proceed with the hearing of the writ petition merits and dispose it off as expeditiously as possible. Writ appeal is disposed of in the terms.
Item number 84.
84 my rehabilitation 30th August.
30th August.
Item number 85.
85 was a case he was on ad hoc promotion. The only point is to be decided when while cancelling the ad hoc promotion whether the principle of natural justice is to be followed or not. That is the simple. That ad hoc promotion was given, that was cancelled because that ORB Act was not followed. Honorable single judge has held that even if that is ad hoc promotion, the principle of natural justice is to be followed.
Why not?
If your lordship will only so promotion was given just 2 months after that has been cancelled because ORB Act has not been are there too. Normally, in a ad hoc motion, your lordship knows that.
But I am appearing for the respondent by way of a caveat. A copy of the appeal memo has not been sought, madam.
The impugned order has been challenged on the ground that the respondents, that there is no need to comply with the principles of natural justice while cancelling the ad hoc promotion of the respondent, as section officer level 2 and reverting him to the post of senior assistant. Stop. The learned single judge has
to the post of section officer.
Sorry?
To the post of section officer.
To the post of section officer. Okay. No. The promotional post is section officer.
Yes, sir. Promotional.
Reversion as senior assistant.
Yes.
That's what I've said. Paragraph. The learned single judge has referred to case law and concluded that the principles of natural justice could not have been avoided. No, compliance with the principles of natural justice could not have been avoided, and therefore quashed the reversion order of the appellate. Paragraph. Having heard learned counsel the parties, the court is not inclined to interfere. It is nevertheless clarified that the impugned order would not preclude the appellant from proceeding in accordance with law if it.
Subsequently, they have been promoted.
Sorry?
Subsequently, they have been promoted.
Oh, all right. In that case, you say the court is further informed that the respondents have even received further promotions. In that view of the matter, the court sees no reason to interfere with the impugned order. The writ appeal is accordingly dismissed.
Item number 86.
86 मतलब शर्त तो पड़ा
8th May.
8th May.
Item 87.
87 your lordship call this matter tomorrow, day after tomorrow.
All right. At the request of counsel, the appellant list tomorrow.
Item 88.
My lord, it is a matter pertaining to disbursement of stipend to ST/SC students, and the honorable court wanted the government to file an affidavit.
24th April we have filed. 24th March.
The affidavit of 11 January.
No, sir. Another affidavit was filed on 24th February. No. 24th February affidavit filed by. I'm just. This is filed on 24th February. Oh, I'm sorry. That is 11th January, but filed on 24th February. Correct.
What is it? No, it's not here. I'm not able to find it. When last time we could not find it. You have a copy?
Yes, I have a copy.
What does it say?
They say that they have laid down guidelines that there will be centralized payment, disbursement, order will be passed. And after that incident.
All right.
And they have given detailed lists.
All right.
But only specific things they have not mentioned. That the court directs the state government to file a supplementary affidavit placing on record details of how many applications for grant of stipend amounts to the students belonging to the SC/ST were received throughout the state in 2022, within what period those applications were processed and orders passed.
No, that Annexure 3 gives that.
Yes.
That is already placed on record in the previous affidavit.
Yes.
That is also noting.
Those details have been given.
Yes.
So the affidavit dated 11 January 2023 has been produced. It sets out the modalities followed by the state for disbursal of scholarships. Pre-metric scholarship among the SC/ST boys and girls. From 2016, 15-16 onwards.
Connected file also same.
It is stated that every year approximately 15 lakh ST/SC students are availing the pre-metric scholarship. Further instructions appear to have been issued to the concerned district welfare officers open petition to monitor that all eligible beneficiaries get the scholarship in time. Paragraph. In view of the above steps taken by the state, no further directions are thought necessary to issue at this stage. The writ petition is disposed of.
My lord, there are two aspects. One about the disbursement of stipend to SC/ST students, and but the incident from which this PIL was originated, the death suicide committed by a class 7 student, 10-year-old, 12-year-old girl, who belonged to the scheduled caste community, but no girl from SC/ST community of that school were paid stipend for last 1 year. There was delayed and it was admitted. I have also filed a written note, my lord. So the second aspect is whether the ex gratia paid of that is 1 lakh rupees is adequate or more
When did the
compensation.
accident happen?
When did the accident happen?
Accident happened on 25th June 2014.
10 years.
And only 1 lakh ex gratia was paid. It was put in the affidavit. We also admit.
Let them represent the director. They will consider.
2014 matters. Now again representation. The whole thing shouldn't start.
Everything admitted, my lord.
No, we have paid 1 lakh rupees. That is admitted. He wants to enhance the amount.
Yes, ma'am.
But if he makes an representation to the government will take a decision keeping in view the.
No, my lord. Now the honorable court must decide that it is grossly inadequate when it is already admitted by all, and even the government admitted and paid only 1 lakh rupees. So there must be enhanced compensation.
The collapse of wall, we had passed a judgment earlier.
That is not in scheduled caste. This type of
this is a peculiar case, my lord.
This is a different type of.
No, this is parents of 7 children who had died due to collapse of the wall.
Yes,
That
my
is
lord.
different.
In my note,
No,
I
that
have
was
mentioned all those judgments.
No, here, what was it? Here, what is the contingency?
Here she committed suicide, my lord,
Suicide.
because her parents could not pay her 10 rupees to buy notebooks. Whereas stipend of 200 rupees per month was not paid to her
Yeah,
for
but
1
this
year.
is not an accident compensation.
Not
This is-
accident, my lord. But here the negligence of the state is.
No, there's no negligence except that payment got delayed. That's it.
Yes. Because not only the victim girl, but no girl from that school were paid.
As regards the suicide committed by the daughter of the petitioners.
No, my lord, I filed the PIL petition.
The suicide committed by a class 7 student of the government girls high school Aska.
My lord, may
On 25th June
I
2014, the
bring
court
to notice of
informed that the government has already paid
the order
an
passed on
ex gratia
20
compensation of rupees 1 lakh.
to the order passed on 27th 9, 2022. Everything was recorded, my lord.
Corrective steps, correct. That's exactly what they've done.
It appears that the state government has ordered an inquiry, has paid the family of the girl a sum of rupees
Having
1 lakh
heard
out of the
counsel
chief
to the
justice relief.
parties, the court does not consider it necessary to issue any further directions apart from what has been issued above. The petition is posted.
My lord, whether enhanced compensation
No.
is in paid or
No, sir, no.
89.
May I please, my lord?
Yes.
By some mistake in understanding the wrong dates have been referred to
I
single
I
judge.
admit that, my lord. I admit that. Let it be remanded back to the
My lord.
honorable single judge.
It is remanded.
The impugned judgment of the single judge has come out, according to counsel for the both parties, recorded certain essential dates and events incorrectly. It requires to be the entire issue where petition therefore requires to be reconsidered. Paragraph that would matter. The impugned judgment dated 3rd July 2019 is hereby set aside and repetition civil. 299 of 2008 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 27th July.
My lord.
Since pleadings are already complete in the matter, the learned single judge is requested to proceed with the hearing on merits, and both parties will cooperate with the learned single judge. Oh, counterpart is not filed.
File, my lord. Everything is filed.
Counter was filed.
File.
Counter was filed.
Counterpart filed.
Yeah, counter filed. Proceed with the hearing of the writ petition merits and dispose it of as expeditious as possible.
Item 90.
May I please, Your Lord? Here is a case, Your Lordship. The candidature of the writ petitioner has been rejected, and that was challenged in the writ petition, Your Lordship. And the impugned order, Your Lordship, may kindly come
No,
to.
that's the opposite party being served. No,
My lord, the counsel was appearing, Mr. Sahib.
Ah,
Very well. Can it be another day, Lordship?
or at the request of Mr. Dalai, list for hearing on.
Yes.
July, not 14, sorry. 19 July.
Let's.
Interim order to cut.
Let's.
I'd like.
Ah.
For orders item number 1.
In orders item number 1, I place of modification, my lord. One list was produced by the petitioner, my lord. Wherein in the said list, they have given the 57% on Lordship may kindly 16/2003. The list was produced by the petitioner IPCO, my lord. In that list, they have given 57 list, but wrongly they have mentioned 56. But 52, 2 times they have typed, my lord, in that list, my lord. Lordship, I got it, my lord. 16/2023.
Sir, two names were repeated, in fact.
Repeated, ma'am.
Two names were repeated. It is 55.
No,
and they have already been paid.
Oh, I see.
Also, the order has been complied with.
All right.
My lord, 1 minute, my lord. They have given 52, 2 times. So they have calculating 56. It is not 56, it is 57, my lord.
No, 56, 5, sir. Two names are repeated.
Oh.
Two names are repeated. That means Samsundar Rao and Chandan Gade, they have repeated 2 names.
Yes.
Now it is 55. But they have.
Has it in any way affected?
Yes, my lord. Yes, my lord. Because they have left 2 names. In my IA, I will explain, my lord.
Compensation
Page 4.
has been disbursed.
In my IA, page 4, my lord. Para 5. 2 names, one Nadia Sethi and one Mohindra Das. Their name is not in the list, but they have given 57%.
No way connected. They were not in the original list, not connected.
They have given, my lord. They have given all the. They are in the original list, my lord. They have given all the documents, my lord.
And 25F, all the compensation, everything has been paid.
But it should be, my lord, 25FF. Your lordship's last order, your lordship have plans to order dated.
But whether it's F or FF, it's been paid, sir.
My lord, your lordship kind of 30th March 22, my lord. 30th March 22, your lordship's order. In paragraph 2, second, my lord, that why the first condition of clause number A of a section 25FF of the said act is found satisfied. Your lordship's order, my lord.
It's okay. Irrespective of that, they have already paid, sir.
Yes, sir. Already paid.
Not paid, my lord.
No, already paid.
No, my lord.
It has been paid, sir. The list is there. I've given to my lord. Already paid.
They have again written a 56 workmen, but it is not 56 workmen, my lord. It is 57, my lord. I am coming here. It is 57, my lord. 2% name they have not given. One, my lord, Nadia Sethi, and another is Mohindra Das. If they will include, it is 57. If they will not include, then it is 55. So I am affected by the 2% name has not been taken.
So I think you have mentioned FF only.
But 25, so far 25F is concerned, 25F I am suffered, my lord. But it should be 25FF, my lord. On that,
No, it should be 25F.
On that date, I have stated that 25FF, my lord.
I don't understand. Which paragraph are you referring to?
My lord.
Which paragraph are you referring to?
In the order sheet, my lord.
Which paragraph?
Yes, in the order.
Order dated 16 January.
Which order? Which order? Order dated?
Order dated 16 March 2023. In paragraph 2, third line, my lord.
Yes.
It's all right, sir. Irrespective of this, they've already paid.
Yes.
It does not make a difference. Earlier order says FF only.
FF, my lord. But there it is a type of Mr.
Sir, he has already paid the money.
I have not received, my lord. Not received, my lord.
No. I have already paid. I have given the list.
As my senior has submitted that it is paid but not paid. I have not received it to the mayor.
Sir.
Sir, we can't get into this disputed question whether they're saying they have paid. Probably you have not received instructions.
Proper today morning, madam. Today morning, I have a telephonic instruction that they have received, madam. My lord, seniors submitted that they have a question, but
have you got receipts on this?
No.
So these are all sent by raised to post, all the address, madam.
No, what checks have been sent?
Yes, sir. Who checks?
What is the
The
date?
individual, everything has been sent.
Now, what is the date on different dates or?
The check date is 3rd April and it was sent on 7th April. All the letters.
Today is only 11th. So maybe it's not reached.
Yes, madam. 3rd April checks.
Every
So you want to check these two additional employees? He's saying Nadia Sethi and somebody.
Mohindra Das, madam. Mohindra Das, madam.
You just check, sir. These are only 2 employees. Just check if they are there.
And if at all, they will give their papers and on scrutiny, I will give it.
All right. It is pointed out that
Your lordship, 25 FF, your lordship
states that
25 FF, my lord. But
sir, does it make any difference if they've already dispatched these checks? Does it make any difference?
Yes, ma'am. It will be high difference, my lord. Because in 25, I don't know how much money they have paid. I have not seen.
So he's given you the list, sir. The last column tells you the number of money paid.
Yes, ma'am. It's a 15 and some odd, they have given that list of supply for example, one, proper one, as a total amount of 15,589. But in 25 FF, and higher amount of the workmen will be get, my lord. Take benefit, my lord.
I don't know.
25 FF, my lord.
What is that higher amount? What is that higher amount? Have you worked out what is that higher amount?
The compensation to the workmen in case of a transfer undertakings where the ownership of the management and they will get the service benefit along with the compensation, my lord.
Sir, here there are several columns.
Yes,
here.
Yes, my lord. Yes, my lord.
What is the difference? Tell us if it is F, it will be this much. FF means this much. Work it out.
They left in 2003. Taken over was in 2004, 5. 2 years after, then much prior to that, they had left.
I pray, your lordship, kindly take out some other date. I have received just now. Your lordship can add some other date.
Mr. SP Mishral, Senior Counsel, has handed over the complete list of the 56 workmen who have already been, according to, who have been paid the compensation amount in terms of the orders of this court. On instruction, full stop. On instructions, he states that there is a repetition of the name of Shyam Sundar Raut, who occurs at both serial numbers 43 and 52 in the said list. However, he has anyway been paid the compensation amount. He states that all compensation amounts have been dispatched by way of check individually to the workmen by registered post, which was posted on 7th April 2023. Paragraph. Counsel appearing for the applicant makes 2 submissions. Full stop. One, according to him, compensation should be paid in terms of Section 25FF of the Industrial Disputes Act 1947 and not Section 25F as has been directed by this court in its order dated 16 January 2023. Stop. Secondly, he states that 2 more workmen, that is Nadia Sethi, son of Bana Bihari Sethi, with employee identity card code number 52737, and Mahendra Kumar Das, son of Niranjan Das, with employee identity card number, code number 53030, are not found in this list, in the list handed over today in court, and their cases are identical to the cases of the others who have been paid. Paragraph. On both the above submissions, Mr. Mishra states that he will have the records verified. And we'll revert on the next date of hearing. List on 11th on a Friday, sir.
Yes, my lord.
12th May. 12th May.
Congratulations.
Item number 2.
The petition was dismissed. The writ application was dismissed for default on 27th October 2022, and I filed my previous restoration application while moving that your lordship was not satisfied and tendered unconditional apology. I have made unconditional apology for my non-appearance on that day. Paragraph 5.
What's the main matter about?
Main matter is that they've deducted the TDS, they withheld the amount towards TDS, but they neither granting me the TDS certificate, the NSIC bill, nor refunding the money which they have withheld. The lordship can have the glance at order dated 9/9/2022.
All right. You say for the reason stated in the application, the unconditional apology tendered by the counsel for the petitioner is accepted. The order dated 27th October 2022 is recalled, and writ petition civil 33205/2021 is restored to file. The main writ petition, you say today this writ petition is restored by virtue of the order passed today in CMAPLs also. List before the roster bench of the roster bench on 3rd May.
Item number 3.
Here also the dismissal was on 24th November, and the main matter is that section 62(5) of the Overnight Act says by rule prescribed, and there is no rule. And similar matter your lordship have fixed to 24th April.
All right. You say for the reason stated, the order dated 24th November 2022 is recalled. CMAPL is allowed. The writ petition is restored to file, and the writ petition will say list on 24th
April.
All right. Before the roster bench.
Item number 4.
The writ application has been dismissed on non-prosecution on 16/1/23, 2023. I filed the application for.
All right. Same order here. When is there any connected matter? No.
No, ma'am.
List for the roster bench on 8th May.
Item number 5.
Writ petition is dismissed on 20 February 2023. I have filed this application for restoration 23/2/2023. My lord.
Restored to file for the roster bench on 9th May.
Item number 6.
Lordship, in this matter also, matter is dismissed due to default because on the relevant day, the counsel could not attend the court due to some personal reason, Lordship.
All right, same order. It's before the roster bench on 9th May.
Item number 7.
7 May, my lord. This was also dismissed for non-prosecution because of the missing of the cause list, my lord. And there's a delay of 36 days, my lord, in filing.
Or delay condoned. Recalled before the roster bench on 10th May.
Publishment.
Item number 8.
Lordship. I filed an affidavit as per lordship's directions with a video clip with the petition.
The joint inquiry report, whether it is on record, the joint inquiry report we have submitted, the inquiry conducted by the social welfare officer and the concerned BDO on 28th February 2023. They have conducted a joint inquiry on the allegation of the writ petitioner, and they found that I think that report is there in the record.
It was submitted on the last occasion.
Yes, that is important. That is the basis of our. My lord, he is not at all a poor person as he is alleged. Sri Abhay Pumar has been sanctioned a PMAY housing during 1920 worth rupees 1,20,000. The house has been constructed over an area 15 to 30 with RCC roof. He is residing.
Deny that. Those things are in the writ petition itself. They have a house.
And he is having a television and he is getting free rice and 500 rupees per month from government. All the benefits according to the scheme have already been extended to him.
And the main challenge is that within that 5. 2049. Within I made all these things.
ओसा कौन है पुणी कौन अभी कमा गिलोनी ना तमे कहि देबे तमे खाली जियो पाखरे थिलो
दिस इज
तमे खाली जियो पाखरे थिलो आ जियो कहले तमे भिको मागु न बिली मो पके आसिल तमे खाली कहलो जियो पाखे रहइबो भिको मागिबोनी रहइली हो गेबा तमे ओटे राव न कर हां एडवोकेट जे मु तमे जियो पाखे रहइलो कहलो मु ये हबो सी हबो मु जिबिनी आउ आसी भिक मागिबिनी पुणी आपण आसी आज एठी हाँ हाँ आस बस कथा आइले आस गोटे कथा घरे कहले हाईकोर्ट रे जवाब दिया हम आप पुणी से आस
See clips. He's admitting everything.
I am just recollecting one thing my honorable judge knows. In Chandi Mandir, there was a beggar sitting on the door, and when he died, at least 20 to 30 lakhs rupees coins and 10 rupees, 1 or 5 rupees.
Sir, you are mistaking. He is not a
just a minute.
He is not a beggar. He is using.
You are saying that he is a beggar.
No, he is begging. He is not a beggar.
A begging means who begs?
No.
And 20 lakhs he has contributed for Jagannath Mandir, which is near our High Court.
Because of that inadequacy of the Madhu Pension Yojana and that 5-page rights.
Madhu Pension Yojana, then you have to file a PI challenging the.
No, it's already challenged. You have not gone to that rate. It's already challenged.
Madhu Pension Yojana is a scheme. You say that it is inadequate. That is a matter to be dealt with. Your Lordship has already disposed it. Stop.
This is just ancillary to. I am not getting
ancillary. How can you beyond this thing?
The state is under an obligation. You are consumer mandate.
State is under the obligation. Yes. Look after the welfare of the entire citizen of the state. Yes. Not only your clan.
He is a victim of the policy decision of the government. 500 rupees.
And your lordship sees that he is having a TV, he is having a house, having iron casted roof. Everything he is having. He is getting free rice, he is getting Madhu Pension Yojana. And still if he chose to beg, then nobody can stop it.
It should not be treated as partnered before this bench. Why is it used to despite that? Specifically put a line not to be treated as partnered. Both of these. March 2023 clearly states, open quotation, list on 11th April 2023, the matter need not be treated as partnered before this bench, unquote. Paragraph. Yet, the registry has listed this matter before this bench. Explanation be called for from the registry for this lapse. List before the roster bench.
My lords, may I say something? The petitioner is personally present here. It's very difficult for him to come every time.
Sir, in fact, again, this is a deliberate overlooking of our order. Have you seen the order which we passed last time?
My lord, he don't have any facility for appearing virtually.
You arrange for him, sir. You're a lawyer. Please arrange. Yes, sir. None appears dismissed.
Item number 4.
Same order.
Item number 5.
Same order.
Item number 6.
Same order.
Item 7.
Alright, I may be permitted to withdraw my lord.
Dismiss is withdrawn.
Item number 8.
None appears dismissed.
Item number 9.
Same order.
Item number 10.
Same.
Item number 11.
11 permitted to withdraw.
Dismiss is withdrawn.
Item 12.
Memo taken on record. Dismiss is withdrawn.
Item number 13.
My please, your lordship, no instruction.
No instructions.
Item 14.
None appears withdrawn. Dismissed.
Item number 15.
Same order.
Item number 16.
Same order.
Item number 17.
Same order.
Item number 18.
Same order.
Item number 19.
Please, your lordship. Lord, here I prayed for passing of the proceeding in view of the fact that the informant as well as the victim, they have shared affidavit before officer of this court to the effect that they do not want to proceed or continue with the proceeding. And they have indicated under the circumstance which or the misconception they have lost the affair.
All right. You say the affidavits of both the opposite party number 2 and the
injured Akshay Kumar Panda
and the injured have been placed on record stating that they do not wish to proceed in the matter against the petitioners. That view of the matter takes the prayer clause and all proceedings consequent that hereby quashed.
Item number 20.
None appears dismissed.
Item 21.
Same order.
22.
Same order.
Item number 23.
May I please, Lordship? Lord, order to recall the witness, Lord, was rejected by the impugned order under Annexure 4.
22.
22 dismisses. All right.
Lord, under Annexure 1, Annexure 4, my Lord, at verse 15, the order dated 5/7/2019, Lord Magistrate, Lord, rejected the prayer of the petitioner to recall the PW3, my Lord. Wherein, my Lord, the petitioner is the informant to the, my Lord, GR case, wherein, Lord, she was allowed to participate in the trials as per the provisions under section 302 of the CRPC, and on the relevant day when the PW3 was examined, in the first hour, my Lord, the advocate for the petitioner was present and no witness was there. It was specifically stated in my petition, so also here, my Lord, you also can see paragraph 4 at page 3, my Lord. It is only submitted that on 2nd March 2019, the case was posted for evidence of the prosecution. On the said date, the learned counsel for the petitioner filed Hajira in the first hour and awaited in the courtroom of the learned SDJM Cuttack for the witnesses who were summoned earlier. No witnesses came to the court in the first hour. The counsel for the petitioner was given a date of the case to 26/4/2019 for the evidence. On 26/4/2019, when the counsel for the petitioner filed steps in the learned court, he came to know that on the previous date, that is on 2nd March 2019, one witness, namely Subhani Sahu, came to the court in second hour and he was examined by the APP and the said witness was discharged. The counsel for the petitioner verified the case record on the same day and found that on the previous date, the said witness Subhani Sahu was examined as PW3 in the case by the learned APP and the said witness deposed completely against the prosecution, which will surely prejudice the prosecution. It came to the notice of the counsel for the petitioner that in spite of the deposing against the prosecution, the learned APP did not take any step to declare the said PW hostile
it also came to his knowledge that without making a call outside, the witness was put inside the witness box by the APP and examination in chief was conducted by the APP. The Learned Counsel for the prisoner informed this fact to the prisoner and a petition was filed under section 311 of the CRPC, and that has been rejected under Annex 4, my lord. And my respectful submission is that the evidence is still on, and the evidence on behalf of the prosecution is not closed till late, my lord.
Sorry. The challenge in the present petition is to an order dated 5th July 2019 passed by the SDJM (S Cuttack) in GR case number 1001 of 2016, declining the informant's application under section 311 CRPC for recall of PW3. Paragraph. This court has heard the submissions of learned counsel for the petitioner, has also perused the impugned order dated 5th July 2019. Paragraph. It appears that PW3 actually turned hostile and did not support the case of the prosecution. However, at that point in time, no move was made to declare the PW3 as hostile. There is no explanation given in the application filed by the informant under section 311 CRPC for the above conduct of the counsel for the informant. Full stop. It appears that on 15th May 2018, the complainant was allowed by the trial court to conduct the prosecution independently. Nevertheless, it was the APP who examined PW3 in chief. Full stop. The learned trial court has held that when at the time of original examination, the informant did not move the court to declare PW3 hostile, then he cannot subsequently challenge the examination of PW3 on the ground that it was conducted by the APP, or to have PW3 declared as hostile. Paragraph. Having examined the impugned order carefully, the court is unable to find any legal error committed so as to warrant interference. There is no merit in the present petition. It is dismissed as such. A copy of this order be sent to the concerned court forthwith.
Pardon, my lord. Item 4, my lord. Pardon, my lord. Item 4. Item 4. Item 4, my lord.
Yes, sir.
After already in compromise, my lord. Which on the package, my lord. Item 4. Unless to the compromise petition and informant and also injured file their affidavit.
All right. The informant
and
opposite party number 2, as well as the injured opposite party number 3 have filed independent affidavits stating that they do not wish to pursue the criminal case against the petitioners. In that view of the matter, take from the prayer clause and all proceedings consequent that are hereby quashed.
Item 25.
Item 24.
25, no instruction.
Please, Your Lordship.
Item number 24.
Might please, Your Lordship. My Lord. Item 24, Your Lordship. The petitioners challenges the initiation of criminal proceeding not in the way as the learned magistrate has approved it. Your Lordship, my Lord may kindly considering the gross misutilization of the provision under 156(3), wherein the magistrate used to send the complaint petition to the police to register as an FIR, the Honorable Supreme Court in Priyanka Srivastava versus State of UP, Ramdev Food Products, and in many other cases have stated that when the complainant is making a complaint in the court, asking the court to send it under 156(3), the court is duty bound to examine whether the complainant has in fact approached the police under section 154 and on non-registration of FIR, under 154 clause 3 before the superintendent of police or not, and that thing the complainant is required to file an affidavit before the magistrate. Because in Priyanka Srivastav case, the Honorable Supreme Court said it is very easy way. Now this is a classic case, Your Lordship, where a person who has been arrested and remained in jail for 2 years and more than that on allegation of cheat fund, and I have produced all the documents to show how they have created forged documents to cheat general public. They filed a complaint case against me, saying that we have misbehaved her. And the learned magistrate, by order dated 18/12/2018, Your Lordship may kindly see page 14. Without following the procedure prescribed for that, simply sent it to police and directed the police to register it as an FIR. This is in gross violation to the dicta issued by Honorable Supreme Court.
Who's for the state?
Yes. Yes.
How can this be possible?
Yes, Your Lordship.
What has happened in the matter? There's no stay here.
My Lord, I have been asked to produce the FIR. That also
No. That was long ago, so more than 3 years ago.
Yes, Your Lordship. That I produced in the meantime.
No. What has happened in the matter?
That is pending. That is still in.
Pending at what stage? At what stage?
Pending at the stage of appearance of the accused persons. The accused persons have been released on bail, and for further appearance, the evidence has not been started. I have obtained instruction yesterday, Your Lordship. The evidence has not yet started.
No, which means charge sheet has already been filed, that means.
Yes, Your Lordship.
Then at this stage, what should be? When charge sheet has been filed, you have other stages. There is no stay granted here, sir. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is discussed.
But Your Lordship, this order 18/12/2000.
No, that's all right. Nothing. Yes.
Item number 25.
No instruction in.
No instructions dismissed.
Item number 26.
Dismissed.
Item number 27.
Also, the item of liberty may be granted to raise all the pleas.
Permitting the petitioner.
Item number 28.
28, my lord, pursuant to the direction of the state level scrutiny committee, my lord, the criminal proceeding initiated against the petition. My lord, Your Lordship now quash the state level scrutiny committee final order.
As I said, I have not followed what it says. Which item number is this? 28. 14. That was a writ appeal, sir.
My lord.
This you point out to the court concern. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed. Right.
Item 29.
None appears dismissed.
Item number 30.
None appears dismissed.
31.
None appears dismissed.
Item number 32.
Same order.
Item number 33.
Same order.
34.
Same order.
Item 35.
Your Lordship, I'm appearing on behalf of Mr. Behra, Your Lordship. The brief has been transferred. Your Lordship, please.
All right. Counsel to the petitioner states the brief has been transferred. None is appearing. Dismissed from office.
Item 36.
None appears dismissed.
Item number 37.
None appears dismissed.
Item 38.
None appears dismissed.
39.
Memo taken on record. Dismissed is withdrawn.
Item number 40.
None appears dismissed.
41.
Not permitted to withdraw.
Dismissed is withdrawn.
Item 42.
None appears dismissed.
43.
Same order.
Item number 44.
Wait, please, my lord. I have challenged the initiation of the 1cc proceeding filed by a private party, ignoring the procedure laid down by Lalita Kumari case and the 154(3) and 20 section 200, my lord. That the person belongs to Calcutta, my lord. He has never come to Odisha after 2007, my lord. What has happened, my lord? The complainant filed a case before the magistrate JMFC, my lord, with the allegation that some persons came and scolded him for 10,000 rupees and he was injured. And he went to the police station and police did not receive the FIR. Therefore, he is filing this 1cc case, my lord. 154 says, my lord, Lalita Kumari case says, my lord, the IO is bound to receive the FIR. If not, if he is not receiving 154.3, my lord, may see, my lord. That is, any person aggrieved by the refusal on the part of an officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of cognizable offences, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him in the manner provided by the code, and such officer shall have all the powers of an officer in charge of the police station in relation to that offence. In this case, my lord, he has not resorted to this 154.3, which is mandatory, my lord. And pursuant to the Lalita Kumari case, my lord, every IO has to register the case unless he has to, the party is to resort to 154.3, my lord. Apart from that, he has not, it is indicated from the complaint petition, my lord, that it at page at page 28, my lord. 28, my lord.
Yes.
The point number 6, my lord.
Yes.
Steps taken by the complaint regarding occurrence, my lord. It says the complainant orally reported to the matter before the IIC on the same day of occurrence, but police did not register the case, saying both the parties are not local. This person, he stays in West Bengal, my lord.
All right, sir.
And apart from that, the Lalita Kumari case is applicable to my case, my lord. That is, I'll place, my lord, and section 202 may be seen, my lord.
Yes.
Section 202
yes.
of the postponement issue of process. In this case, my lord, after filing of the case, the magistrate took the cognizance of the matter, my lord.
Right.
Any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance or which he shall made over to him under section 192 may, if he thinks fit, and shall in a case where the accused is residing at a place beyond the area in which he is exercising his jurisdiction. My lord, I am emphasizing this one, my lord. Postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by the police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is a sufficient good ground proceeding.
Yes.
My lord, she has to postpone the proceeding, my lord. Either what she will do, postpone the issue of the process against the accused, and either inquire into the case himself. He has not inquired into the case himself, my lord. He has directly taken cognizance of the matter, my lord.
Yes.
Or direct an investigation to be made by the police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding, my lord.
Yes.
I pray, my lord, taking into consideration of 2021 and 156, 154.3, my lord, 154.3, that the order that has been order taking cognizance against the petition that may be quashed and sent back to the magistrate again for inquiry of the matter, my lord.
The respondent served.
Sir.
Mhm.
That is not.
The order is at, my lord, that impugned order is at page 10.
So nothing, the AD says that neither AD nor notice been received back.
My lord, let us take the.
Why waste? See, you got the stay of this for last 4 years.
No, stay. He is on bail, my lord. He is on bail, my lord.
So the last 4 years anyway, you have a stay, sir. So nothing has moved. Because of that, you have enough time now. The whole idea of postponing was so that.
No, not that. Postponing idea is to quashing of the entire proceeding, my lord. On the strength of 156.4 and that 1, my lord. 201 of the CRPC, my lord. Sections.
You say the challenge in the present petition is to an order dated.
And the Lalita Kumari case, my lord, that I am pressing, my lord.
No, but you've not you're only agreed with the cognizance order, right?
Yes, my lord.
The challenge in the present petition is to an order dated 14th May.
On
14th January. What is this? 14th? Is it 5th January or 14th?
No, that is not 14th January. That is
5th January.
5-1, that is, my lord. 5-1-18, my lord.
5th January.
That is January. Order number 15, probably. That side, left-hand side.
Order dated 5th January 2018. Passed by the JMFC. Saintala. In 1cc number 1 of 2017. Taking cognizance of the offence under sections 294, 341, 323, 420, 506, Read 34 IPC. Against the present petitioner, who happens to be a resident of Kolkata in West Bengal. Paragraph. Under section 202 CRPC, 202(1) CRPC, where the accused is residing at a place beyond the jurisdiction of the court, the magistrate is required to postpone the issue of process and, open quotation, either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as it thinks fit, for the purpose of deciding whether or not there is sufficient ground for proceeding. Full stop paragraph. In the present case, there is a non-compliance section 202(1) CRPC. Inasmuch as on the very first day of considering the complaint filed by the respondent, by the opposite party, the JMFC has straightaway proceeded to issue, proceeded to take cognizance and issue summons to the accused. This is also contrary to the dictum of the Supreme Court in Lalita Kumari versus
Lalita Kumari case, my lord, that is 2000
full cost title, sir.
My lord. Lalita Kumari versus Government of UP.
Government of UP.
My lord.
Give it the citation.
2014-2 SEC 1, my lord.
2014-2 SEC, page 1. Paragraph. For the aforementioned reasons, the impugned order dated 5th January 2018 is passed with the JMFC Saintala set aside. And the case 1cc number 1 of 2017 is directed to be now proceeded with by the JMFC Saintala afresh by strictly following the requirements of the CRPC. The matter be listed in the said court on 1st June 2023. A copy of the order be sent to the concerned court forthwith.
My lord, that 154.3 that maybe I have my submission is that he has not.
Nothing is going to happen, sir. Nobody will do anything about this. Yes.
Item 45.
Yes.
My lord, have directed to appear before the.
On 1st June. Sir. Item 45.
None appears dismissed.
Item number 46.
None appears dismissed.
Item number 47.
None appears dismissed.
Item number 48.
IANC dismissed. None appears dismissed.
Item number 49.
None appears dismissed.
Item number 50.
Same order.
Item 51.
Same order.
That's it's turned infructuous, your lordships.
Infructuous dismissed. All right.
Item number 52.
952 in respect of co-accused reasonable court relegated me to raise the point during trials. So
Permitting the petitioner. Yes. Permitting the petitioner to resolve peace at the appropriate stage.
53.
Obliged.
All right. None appears dismissed.
Item number 54.
53. Sorry.
53.
In this case, my lord, I have challenged the postponement of the 205 consideration. And as to your lordship, page 12, your lordship may see. Last line is, hence defense counsel is directed to produce the accused, namely Vijay Marana and others.
No order has been passed in this.
No order has been passed.
Nothing remains.
That may be considered now because how can after the production of the accused, the 205 can be considered. The statute says that 205 considered once he appeared through advocate and asked for the petition to be considered.
See, here no order has been passed in this petition. It's been pending for how many?
But he's asking
4 years.
But he's asking for the production of the accused.
No stay of that order. The case would have been would have progressed now.
No, my lord, because also the other accused has challenged it under section for non-sanctioning of the.
Then you take advantage of that.
My lord.
No order has been passed in the present petition so far in the last 4 years. Given the nature of the impugned order, petition has become infructuous. It is dismissed.
Stay has been there. That's why it is.
There is no stay here, sir.
But here, but the other.
There is no stay here.
CRLMC 2208 by 2019 stay is there.
Maybe, sir, in 2209, which is what was just now called out, no stay. Right.
Item 54.
None appears dismissed.
Item number 55.
None appears dismissed.
56.
Same order.
Item number 57.
Same order.
Item 58.
Memo taken on record, dismisses withdrawn.
Item number 59.
Item 59 have been permitted through BC, my lords. My lord, the application may be disposed of with liberty to renew the prayer at the appropriate stage, my lords.
All right, permitting the petitioner to resolve this.
Item number 60.
None appears dismissed.
Item 61.
Same order.
62.
62, my lords, permitted to withdraw with a liberty to file a better application.
No. Permitting the petitioner to resolve peace at the appropriate stage.
Item number 63.
63, last occasion, my learned friend was to take instruction regarding mediation. He's saying that it's not possible. So, my lord may hear this on merit. Arises out of a DV Act proceedings. Now, so far as the petitioner number 1 is concerned, he is the husband. So far as he is concerned, my lord may allow the proceedings to continue against him. But so far as the others, my lord may kindly hear me. What has happened? I have prepared a short 2-page note. First point is that 2009 she left and the complaint was filed in 2016 under the DV Act. There are multiple proceedings. So far as I'm now only focusing on 2 to 4, there is one judgment of the Honorable Supreme Court. I have given that, a copy also I have given. My lord may kindly see. So far as the in-laws and remote relatives, they have said that if it's a belated complaint, it may be a fit case for caution. That was under 498A. The relevant paragraphs here would be paragraph 2, which describes.
Who is appearing for the wife? You are there.
I am for the wife, my lord.
You want to pursue against the in-laws or only the husband?
My lord, allegation was made that section 12 petition was filed. It was questioned on the ground of limitation. My respectful submission is that limitation will not apply, because if an offense is committed, then the question of limitation under 468 comes. The offense is committed if the order passed under 12 is not implemented. That is the statute, my lord. It becomes an offense under 31 of the Domestic Violence Act. Then probably 468. My lord, there is a direct judgment, my lord, which says limitation will not apply. Limitation will not apply.
What was my question to you?
Yes.
What are you answering? You didn't.
Your lordship said whether I should proceed against the in-laws or not. My lord, they have all been made parties in this case, my lord.
Of course, they've been made parties, sir. My question to you: do you want to proceed against them or not?
That I can take instruction only because now since they are parties in the proceeding, my lord.
So you can make anybody under the sun, even people in Australia and
there are certain allegations.
Canada
There are certain allegations against them also, my lord. That's why.
All right. If you're not so adamant, then
no, I'm not adamant, my lord.
It's all right. It's all right.
In fact, the judgments would cover. So far as the in-laws, I may have a good case.
Correct.
So far as the husband, I bow down. It may continue.
Yes.
So far as the in-laws, my lord may kindly see.
Right.
That judgment of the Honorable Supreme Court, paragraph 2.
Yes.
Where they describe the appellants therein.
Yes.
This is Chandralekha versus State of Rajasthan.
Right.
And then important would be paragraph 9.
Right.
We must at the outset state that the High Court's view on jurisdiction meets our approval and we confirm the view. However, after a careful perusal of the FIR and after taking into consideration the attendant circumstances, we are of the opinion that the FIR lodged by respondent number 2 insofar as relates to appellants 1, 2 and 3 deserves to be quashed. The allegations therein are extremely general in nature. No specific role is attributed to each of the appellants. Respondent number 2 has stated that after marriage, she resided with her husband at Ahmedabad. It is not clear whether appellants 1, 2 and 3 were residing with them at Ahmedabad. The marriage took place on 9/7/2002 and respondent number 2 left her home on 15/2/2003. That is within a period of 7 months. Thereafter, respondent number 2 took no steps to file any complaint against the appellants. 6 years after she left her house, the present FIR. So all these facts, my lord, are similar and these are all general allegations made here. From the complaint itself, this would be telltale. If my lords would see the complaint in this case, the relevant paragraphs, it begins from page 13. In the at page 14, she states about the date of marriage 6/7/2007. Paragraph 3. She says that the aggrieved person number 1 and OP number 1 stayed together at the matrimonial house for about 7 days. And thereafter, OP number 1 left for Raigad, leaving aggrieved number 1 behind her in-laws. Aggrieved number 1 was never well attended. So these are the nature of allegations. Well attended, past rustic comments in the name of parents. And all this after almost 9 years of the marriage. Paragraph 4, there are some allegations. Paragraph 5, tantric puja in her room. And it is not specific vis-a-vis anybody, just in-laws in general.
Yes, sir.
And my lord, a series of judgments of the recent Supreme Court where they said that these remote relatives have to be exempted. That, my lords, I'll just place.
No, but these are not remote. In the sense, this is father-in-law, mother-in-law.
Father-in-law, mother-in-law, and brother-in-law.
Yeah, they're not remote.
They are not remote.
No, my lords, may kindly see the paragraphs from Preeti Gupta, my lords. 2010 7 SCC 667,
yes.
Paragraph 30. So what has been said vis-a-vis 498A would also apply to DV Act cases, particularly in the backdrop.
Yeah, that's well said. Yeah.
My lord, recent judgment also I have given.
All right.
They say that it's an abuse of process.
Yes.
No, paragraph 5. The aggrieved person number was never allowed by her mother-in-law to spend any time with OP number 1, even during his short visit to the matrimonial house during holidays at his workplace.
Where are you reading?
Sir, paragraph 5 of the complaint petition, my lord. Annexure 1.
Page 15.
Page 15.
Yes.
That your lordship got it, my lord.
Yes, yes.
That the aggrieved person number 1 was never allowed by her mother-in-law to spend any time with the opposite party number 1.
No, no. What is the date for all this?
My lord?
What is the date when all this happened? Nothing. So perfect definition of vague, correct? Classic textbook example of vague. The only date is in para 1, sir, for your kind benefit. Para 1 is the date of when the marriage took place.
Yes, ma'am.
Whoever drafted this had no idea of dates, no idea of the case law, nothing. And when is this being filed, sir? After marriage was in 2007. When is this being filed?
2016.
Because so for 9 years, no need to tell the court what happened in the 9 years.
Husband filed a case for divorce, seeking
only
divorce. Then
suddenly she remembered all this.
No, my lord.
That you're making your case worse and worse now. So clearly a backlash.
No, my lord.
After the husband files a case for divorce, now say, okay, let us start.
She has made allegations against the mother-in-law and father-in-law.
Where is the date, sir? When did those things happen, which you're talking about? You're filing it 9 years after the marriage.
But on that ground, my lord, proceeding cannot be
quashed. This is the classic ground, sir, which means you're not aware of the case law.
No, my lord, this judgment says, my lord,
which means you're not aware of the case law.
My lord, with due respect, this is a judgment of 2022, my lord, which says, my lord, if an order passed under 12 is not implemented, that becomes an offense.
If you invoke the DV Act 9 years after the marriage, without giving any reference to any dates about all these allegations, how is it sustainable?
Destitute lady, where she'll go, my lord, she has been driven out of the matrimonial home.
Therefore, you make any allegation you want.
No, specific allegation.
I see. This is specific.
May not be date, but specific allegation against each of the individual.
If there's no date, it's specific.
Specific allegation against each of the individual, my lord.
All right. You proceed.
Yes,
you proceed and argue whichever way you want. All right.
That in-laws of the aggrieved person, that paragraph 5, my lord, I was reading, my lord, page 15.
Yes.
That the aggrieved person number was never allowed by her mother-in-law to spend any time with the OP number 1. Even during a short visit to the matrimonial house during holidays at his workplace. The mother-in-law of the aggrieved person never wanted the OP number 1 to develop any emotional relationship with the aggrieved person number 1 because he thought that OP number 1 would no longer be in her control and she would be debarred from enjoying the monthly salary. The in-laws of the aggrieved person number 1 used to arrange for tantric puja in her room during midnight during absence of the OP number 1, for which she has been terrified in number of occasions, my lord. Then, my lord, next page. 5th line from the top, my lord. 4th line. The in-laws of the aggrieved person number 1 always instigated OP number 1 against her over phone and in person, for which the OP number 1, believing their version and without giving her any opportunity to explain, scolded her in filthy language, both about herself and her parents. The in-laws of the aggrieved person number 1 never wanted her to go and stay.
So, in-laws are how many people, sir?
Mother-in-law and father-in-law.
And?
Okay. Father-in-law, my lord. Brother-in-law.
So there are 3 in-laws.
Yes.
Correct? And this entire paragraph collectively refers to them as in-laws, in-laws, in-laws. And this according to specific allegation.
Well, I cannot improve upon this, my lord.
Thank you for telling me that.
No,
it's very kind of you to say that.
No, it's not kind of.
Very kind of you to say that.
The complaint is on record, my lord.
Because you're so aggressive and vociferous when I try and point out there are no specific allegations. Very kind of you to say that.
I'm not aggressive, my lord. I'm just defending my client. Due respect to my...
Fortunately, this is live streaming. If somebody had heard you 5 minutes ago, they will know how aggressive you were. Yes. When your case is weak, try and good advocacy is when your case is weak, don't become aggressive. Weakens your case. When your case is weak, try and persuade.
I'm sorry.
I'm sorry. You're sorry to your clients.
I'm sorry.
See, when your clients have a difficult case, you have to know how to present it. When you have a weak case and you start shouting, the problem starts there. Nothing to back it up. The more and more you become aggressive, it becomes weaker and weaker when you start reading. No specific allegation.
But dates have not been given in the complaint.
Not only dates, sir. There are 3 people you have named as accused. No specific allegations against any of the accused. This is a classic case of how not to draft a complaint. Somebody who's drafted this complaint has never bothered to read case law.
I to that extent, I concede, my lord, that there's no specific date.
Yes.
But allegations have been made. That's all.
That's the problem, sir.
Against the parents.
That's the easiest thing to do, sir.
And
making allegations is the easiest thing.
He filed before filing a WS, my lord, husband filed a petition seeking quashment of the proceeding on the ground of limitation against all. The original court dismissed it on the ground that it's a mixed question of law and fact and it will be decided along with other issues. He carried the matter to the appellate court. Appellate court also confirmed the order. The appellate court says you first file your written statement, then evidence will be read. On that basis, it will be decided, my lord. So the question raised by him is that the proceeding is not to be initiated because it is barred by limitation. So both the courts will have proceeded on that footing to decide that issue, whether it can be barred under law or not. They say it's a mixed question of law and fact. It will be decided along with other issues, my lord.
The present petition under section 482 CRPC seeks the quashing of the orders dated 15th March 2017, passed by the Sub-Divisional Judicial Magistrate (SDJM) Bhubaneswar, CMC number 706 of 2016, filed by the respondent, opposite party, under section 12(1) of the Protection of Women from Domestic Violence Act 2005 (PWDV Act). Also, the petition seeks quashing of an order dated 1st September 2017, passed by the Sessions Judge Khurda at Bhubaneswar, dismissing the petition under section 29 of the PWDV Act, thereby affirming the order dated 15 March 2017 of the SDJM. Dismissing the petition filed by the present petitioners, questioning the maintainability of the aforementioned CMC number 706 of 2016 on the ground of limitation. Full stop. Inter alia, both the SDJM and the learned Sessions Judge took the view that the question of limitation was a mixed question of fact and law, which could be gone into only the stage of trial. Paragraph. The background facts are that petition number 1 was married to opposite party number 1 on 6th July 2007. Stop. A son was born on
2009.
No, I think 2008.
Oh, sorry. On 23rd of May 2008.
Yeah, on 23rd May 2008. Paragraph. In the complaint filed under section 12(1) of the PWDV Act on 23rd November 2016, opposite party number 1 is silent about when she left the matrimonial home, whereas according to the petitioners, she left the matrimonial home sometime in 2009. Mr. Gautam Mishra and his senior counsel for the petitioners refers to the application to section 12(1) of the PWD Act filed by opposite party number 1 and submits that the allegations therein against the petition number 1 husband and petitioners 2 to 4. No, you say Mr. Gautam Mishra, learned senior counsel for the petitioners, at the outset submits that he's pressing the present petition for quashing of the CMC number 706 of 2016 only as far as petitioners 2 to 4, that is the father-in-law, mother-in-law, and brother-in-law are concerned, and not petition number 1, who happens to be the husband of OP number 1. Paragraph. Referring to the application under section 12(1) of the PWDV Act, he submits that the allegations as far as petitioners 2 to 4 are concerned are at best vague and unspecific. And the entire petition has been made belatedly 9 years after the opposite party number 1 left the matrimonial home. Stop. He refers inter alia to the decisions in Chandralekha versus State of Rajasthan 2013, 14 SEC 374. Preeti Gupta versus State of Jharkhand 2010, 7 SEC 667. Srinivasan versus State 2019, 8 SEC 642. And the recent judgment in Kehkashan Kausar was the State of Bihar 2022, 6 SEC 599. Stop. Counsel for the opposite party number 1, on the other hand, defended the impugned orders of the SDJM and Sessions Court and submitted that the question of limitation, if any, was a mixed question of fact and law. And the parties could not avoid facing trial on that score. Full stop. As far as the allegations in the petitioner, the PWDV Act was concerned, he submitted that there were allegations made against petitions 2 to 4, which were specific, although the exact dates in which the various incidents occurred were not mentioned. He submitted that the non-compliance of orders passed by the court in proceedings under the PWDV Act would itself constitute an offense. And therefore, the court should not at this stage, interfere with the proceedings under Section 482 CRPC. The above submissions have been considered. On a perusal of the order dated 15 March 2017, it is seen that, barring the last paragraph of the order, it merely sets out all the contentions of the petitioners and simply states that since PWDV Act is a beneficial law intended to provide relief to a destitute lady and has a retrospective effect, open quotation, the cause of domestic violence can be better appreciated at the time of trial and not at the present stage, unquote. As far as the judgment dated 1st September 2017 of the Learned Sessions Court is concerned, again, it proceeds on the basis that all the contentions raised by the petitioners, open quotation, shall be gone through during the trial of the case, and the same cannot be considered, entertaining a preliminary objection, unquote. That order also does not deal with the objection as regards the complaint under the PWDV Act being highly belated, nearly 9 years after the opposite party number 1 left the matrimonial home. Paragraph. A perusal of the application under the PWDV Act reveals that it is silent on when the opposite party number 1 actually left the matrimonial home and what transpired during the 9 years till the filing of the complaint. Full stop. Counsel for opposite party number 1 volunteered that petition number 1 husband had filed an application for divorce under section 13 bracket 1 of the Hindu Marriage Act 1955 bracket CP number 234 of 2017 bracket in the family court at Bhubaneswar on
25/3/2017.
25th March 2007.
On 25th March 2017.
Administrative file.
After receiving the notice.
No, my lord.
This was filed prior.
Prior. CMC.
Yes. DB Act
but
was
notice
prior.
Notice went in the CMC, right?
My lord.
Yeah, after receiving notice in the CMC.
My lord.
I've just dictated that you filed an application for divorce.
My lord. My lord.
2017, my lord. My application and a domestic.
Sir, I'm dictating. You're not even waiting for me to finish a sentence. This is the whole problem.
Sorry, my lord.
We are sorry.
After receiving notice in the CMC number 706 of 2016. Full stop. This still does not explain why PW opposite party number 1 had to wait for 9 years. Had to wait for over 9 years to file a complaint under the PWDV Act in relation to events that transpired in 2007, 2008, and so on. In other words, there is no valid explanation offered anywhere in the complaint why the complaint was filed belated. Paragraph. Secondly, specific to petitioners 2 to 4, who are the single court's in-laws, the court finds that in many of the paragraphs of the complaint, there are general allegations against all the single court's in-laws and no specific allegation pertaining to each of them. Full stop. Importantly, many of the allegations are without any dates being mentioned. And therefore, at best can be termed as vague and unspecific and non-specific. Full stop. The person drafting the complaint definitely did not keep in mind the requirement of law that allegations have to be specific, particularly when they concern several accused persons. And further, that it has to be specific to each of them. Paragraph. In Chandrelekha vs. State of Rajasthan Supra, the Supreme Court observed in para 9 the Supreme Court, while quashing the FIR pertaining to the in-laws, observed that, open quotation, the allegations are extremely general in nature. Full stop. No specific role is attributed to each of the appellants. Unquote. It also noted that in that case, that in the facts of the case, the complaint had been filed 6 years after the complainant left the matrimonial house. Full stop. It was observed, open quotation, in our opinion, such extraordinary delay in lodging the FIR raises grave doubt about the truthfulness of the allegations made by respondent number 2 against appellants 1, 2, and 3, which are, in any case, general in nature. Unquote. Again, in Priti Gupta, the state of Jharkhand, Supra, while quashing a complaint under Section 498 capital A IPC against the relatives of the husband. The court cautioned that such allegations per open quotation required to be scrutinized with great care and circumspection. Unquote. And that open quotation, the tendency of implicating the husband and all his immediate relations is also not uncommon. Full stop, unquote. And advice was also no, you say the court also reflected on the role of the members of the bar and observed that they have an obligation to ensure, open quotation, that the social fiber of family life is not ruined or demolished. Full stop, they must ensure that exaggerated versions of small incidents should not be reflected in the criminal complaints. Full stop, unquote. Srinivasan versus Supra.
Paragraph 6.
Yeah. When there were bold allegations made against the relatives of the husband and other family members, the court observed that if the proceedings were allowed to go on, it would amount to an abuse of the process of court. In Kekasan Kausar was the state of Bihar, Supra. Again, it is observed in para 17 as under. Reproduce para 17. Paragraph. In the present case, the court finds that as far as petitions 2 to 4 are concerned, the allegations in the complaint are vague, not specific to each of them, and significantly, the complaint itself appears to be belated without any valid explanation for the delay in filing it. Paragraph. for the aforementioned reasons, in light of the legal position explained in the aforementioned decisions. As far as petitioners numbers 2 to 4 are concerned, this court, while setting aside the orders dated 15 March 2017 of the SDGM, and the order dated 1st September 2017 of the Sessions Judge Khurda at Bhubaneswar. SDGM Bhubaneswar, Khurda at Bhubaneswar. Quashes case, the CMC number 706 of 2016 under section 12 bracket 1 of the PWDB Act. It is clarified that this order does not cover petition number 1. Whose contentions are left open to be urged at the appropriate stage in the trial court. The petition is disposed of in the above terms.
You're on grid. Item number 64.
May I please, Your Lordship? I may pardon, I am appeal through VC Millard.
Yes, please.
Yes. The impugned order is at Annexure 1, page 9, Millard. Before that, I would like to state the facts, Millard, that the entire dispute revolves around a partnership deed, Millard. A partnership deed was executed between the complainant and the accused petitioner in 2013. Am I audible, Millard?
Yes, please.
In 2013, the partnership deed was executed for the business of transport business, Millard. Thereafter, in 2015, the complainant himself sent a notice for dissolution of the farm, Millard. And the petitioner accused replied to that for appointment of arbitrator. Thereafter, he pursued to several means for settlement of the dispute. But instead of that, the accused was on a FIR. That was a complaint case before the SDGM Bhadrak that was converted to GR case, Millard. That is the FIR dated 22/11/2016, Millard. Thereafter, on 10/1/2017, that order is an Annexure 1, page 9, Millard. To cognizance.
Notice served here.
The magistrate took cognizance, irrespective of the fact that the charge sheet has been filed, stating that no prima facie case is made out. That charge sheet is at page 22, Millard. Page 22, Millard. May I read the last paragraph, Millard? Page 22, Millard.
Yes.
As there is prima facie evidence under 406, 420, 294, 506 IPC is not well established against the accused person, namely Subhendra alias Subhendu Raut, son of so and so, in Bhadrak town, the such and such. I submitted the CS number such and such against him, showing him not arrested to face his trial in the court of law. But irrespective of that, even the matter is civil in the dispute is civil in nature, the learned magistrate took cognizance, Millard.
Yes.
I filed seek the invocation of section 482 CRPC. That order is at Annexure 9, page 9, Millard. So also for quashing of the entire criminal proceeding, Millard.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The interim order is vacated.
Item 65.
Mail, please. Well, I am from the PC Millard. Let it come after tomorrow along with the mistakes I have filed, Millard, 1240/2023, because in that case the matter has been compromised in between the parties, Millard. The compensation has been given to the victim, Millard, as per the direction of the Honorable Court, Millard. That
what is the offense? What is the offense under, sir?
304A, Millard, the offense, and the petitioner is my lord, the company who is it is his duty to supply the manpower, my lord, to the companies. And the Godrej company he wanted some persons, and for that the petitioner company appointed some persons, not appointed, that supplied there some persons for their work, skilled persons. The Godrej company, while one person that doing his work, at that time Nesco is one line connection for which connection can be connection. He fell down from the work and passed away. And for that, the case was that this FIR was filed by one Varun Kumar Giri, who is ASI of that police station. For which the petitioner, even though he has no nexus or he has no role, but his name has been entangled. For which in the meantime, members of the that victim filed the case before the commissioner, that the employment commissioner at Calcutta, for which he passed the order 6,57,640, which has been already paid to the victim, that widow of that person. And that matter has been already compromised. Everything is done. There is no role at all, and which the petitioner has filed this case for passing of the FIR. So far, the petitioner is only
304A is not compoundable, sir.
But in the meantime, the compensation has already been given by the Godrej company. Everything, and there is a big chance of giving that conviction against the petitioner, since he has no role at all in this. So
you pointed out to the trial court in the appropriate state, sir. That's better. Permitting the petitioner. You pointed out, sir, the appropriate stage, permitting the petitioner to raise all pleas at the appropriate stage before the trial court. The petitioner is dismissed. All right.
Item 66.
Item 66, no instruction.
No instruction.
Item 67.
My lord, item number 67. This matter has become infructuous, man.
All right. Dismissed as infructuous.
I am appearing for the opposite party.
All right. All right.
68.
May I please, your lordship?
Yes, please.
This is a case, my lord. Was arising out of a complaint. I have filed this application for quashing.
Yes.
So far, my lord, so far the accused number 1 is concerned. Accused number 1 is the Chief Executive Officer, CEO, Swaraj Tractors, my lord. He sits at Chandigarh. What happened in this case, my lord, a local farmer, he has purchased a tractor from a local dealer, my lord, at Kendrapada. Subsequently, the tractor was all right and the dealing was all right. Subsequently, he claimed certain papers. The papers means, my lord, the local dealer has arranged a loan through another financier, that is L&T financier. And while he went to demand his papers, my loan papers for registration of the tractor at the RT office, they made certain delay, for which he was prejudiced, for which he has filed a complaint, my lord, where he has made the CEO at the party, CEO who sits at Chandigarh, my lord, at Punjab, at the party, he doesn't know anything. There is no allegation against him. There is no allegation. If your lordship may permit me to place the initial statement, which I have annexed, he has not whispered a single word against me. And still the magistrate has taken cognizance against me. Your lordship may kindly see page 12. That is the initial statement of the complainant. I am the complainant. I know the accused persons. I filed the case against Anand Motors and L&T Finance and Swaraj Company. On 4/11/17, I went to Anand Motors, Kendrapada, for purchase of one tractor. Kendrapada means local. I deposited rupees 3 lakhs at the search counter and Anand Motors, but they did not give me the money receipts. Rather, stated that it will be supplied to me through the post.
What is Swaraj Tractors?
On the next day. On the next day.
No, so Swaraj Tractors is a partnership firm.
No. Main is the manufacturer.
The name of the tractor is Swaraj, is it?
Swaraj Tractor, yes, my lord.
But the company is Mahindra.
Yes.
So the company is not made an accused.
No, yes. That is also decision, my lord. If the company
I think on that short ground we can do it, sir.
Yes, ma'am. Yes, ma'am. That is a decision,
it is seen that the
reported in my lord.
Present petitioner has been arraigned as an accused in his capacity as Chief Executive Officer of the Swaraj division of Mahindra and Mahindra Limited, whereas the company itself has not been made an accused. Full stop. On that short ground, following the decisions in Anita Hada versus Godfather Tours and Travels. That judgment is not here.
Yes, ma'am. That is Sarath Kumar's.
Godfather Tours and Travels, 2012, 5 SCC 661. Followed in Sharath Kumar Sanghi versus Sangeeta Rane, 2015, 12 SCC 781. And Ravindranath Bajpayee versus Mangalore Special Economic Zone Limited, AAR 2021 SC. No, just take those two, Sarath Kumar. The ICC number, case in ICC number 172 of 2019, pending the court of the SDJM Cuttack, and all consequential orders and proceedings insofar as they concern the present petitioner are hereby quashed.
Item 69.
Obliged.
Right.
69.
No, please, Pradeep.
Item number 70.
Item 70 may please. In that case, the case has been registered under section 498 34 of IBC and read with 4 of DP Act. And in that case, the opposite number 2 married to Himanshu Bhushan or Ansik on 21/7/10. And in the said allegation, the present petition challenging the order dated 2/6/2017 passed by the Lord Master Militia, which is annexed in Annex 2 Militia. In that case, that a compromise has already been made between the two parties. If my lordship will give in one date military adjournment, I will file
the petitioners claims that the parties have already compromised the disputes. I will request this for the roster bench on 10th May.
Item number 71.
Obliged.
No, please.
Item number 72.
And for the OP number 2, man.
No, please, the petitioner.
Item 73.
73, may I please the Lordship, my Lord? Here I am challenging the order taking cognizance for the offence under section 420, 294, 506, 34 of the Indian Penal Code. Here, my Lord, arising out of a private complaint case, my Lord. The petitioner at that time was a chairman of the college. He given some work, my Lord, to the complainant with advance money of 40 lakhs, my Lord. But he did not, my Lord, in the midst of the work, my Lord, he fled away. And your Lordship kindly see page, I have annexed, my Lord, that is Annexure 5, my Lord. Here, my Lord, we have written to the complainant to come and, my Lord, settle the dispute, my Lord. He has not settled, my Lord. Thereafter, several requests, my Lord, also made and other annexure, my Lord, your Lordship kindly see. Since 2000, your Lordship kindly see also page 31. We have also in 37, 2016 wrote a letter, but without, my Lord, settling the dispute, my Lord, he has filed the present complaint case with, my Lord, all false allegation that though we have given some money, but there is another amount of payment due, my Lord.
All right. You say despite service of notice, none appears for opposite party number 2 complainant. Paragraph, the present petition seeks the quashing of ICC 1CC number 1 of 2019, filed in the court of the GMFC Digapandi by the opposite party number 2 complainant against Intelia the College of Pharmaceutical Sciences of and the present petitioner in his capacity as
At that time, chairman.
chairman of
That college, my lord.
but say some V. Jagannath Rao.
My lord. At that time, your lordship kindly see page 7, my lord. Page 31. That is office of the chairman, College of Pharmaceutical Science, Barampur. That is in the top, in the bottom, my lord. The petitioner signed this. P. Satyanarayan, chairman, College of Pharmaceutical, Barampur. And now he is member.
No. In the complaint, sir.
My lord. In the complaint, my lord, your lordship kindly see that is page 4. Accused column number 4, your lordship, the secretary member, Swans, P. Satyanarayan.
No. Where are you reading?
Page 9, my lord, your lordship kindly see. Accused number 4, name and address of the accused, my lord, in column number 3.
Secretary, sir.
At that time, he was secretary member, Swans, my lord.
That's what. So, who at that time, at the relevant time, was the secretary of the CPS, College of Pharmaceutical Science bracket CPS. What is this member GPCDA means what?
That is my lord, Gonjam and Fulbani Chemistry and Druggist Association, my lord. That is
okay. Very well. The prayer in the present petition is for setting aside an order dated 19 June 2019, passed by the JMFC Digapandi. Taking cognizance of the offences under sections 420, 294, 506, read with 34 IPC against all the accused persons, including the present petitioner. Paragraph. Specific to the present petitioner, when the complaint filed is perused, it is seen that it is about non-recovery of a sum of money due to the complainant as a result of construction works, plumber works, electrical and sanitary works carried out at the CPS. There is no specific allegation against the present petitioner. The only allegation is against specific allegations, if at all, with a date, is against the chairman, CPS, who at that time was one V. Jagannath Rao. Otherwise, all the allegations are vague and non-specific. It appears to the court that what is essentially a civil dispute about non-payment of monies due pursuant to a contract has been given the color of a criminal case. We'll stop. Paragraph 8. In the impugned order, the learned JMFC appears to have overlooked the above facts and has erroneously taken cognizance of the offences against the present petitioner. We'll stop. Therefore, to that extent, the impugned order dated 19 June 2019, the JMFC, in 1CC number 1 of 2019, is hereby set aside. Full stop. It is clarified that, no, full stop. Accordingly, 1CC number 1 of 2019, pending the court of the JMFC Digapandi, and all proceedings and orders consequent thereto, insofar as it concerns the present petitioner, will stand hereby quashed. The petition is disposed of the doctors.
Item 74.
None appears dismissed.
Item number 75,
Same order.
76,
Same order.
item 77, and 78.
Memo taken on record, dismissed as withdrawn.
78. Item 79,
None appears dismissed.
Under 79 will be permitted to withdraw.
Okay, dismisses withdrawn.
item number 80.
None appears dismissed.